All right. I'd like to call to order the November 5th meeting of the Sunshine Ordinance Task Force. Clerk?
On the call of the roll for the November 5th Sunshine Ordinance Task Force meeting, Member Rumbold?
Present.
Rumbold present. Member Winston?
Present.
Winston present. Member Wolf? Wolf absent. He did call and he is ill today. Member Copra, he did call. He is still finishing up a class schedule and he was unable to make it at today's meeting.
You got it.
Member Pilpil?
Sick but present.
Pilpil present. Member Hepner, we were informed that he would be arriving late today. Member David?
Present.
David present. Member Fisher?
Present.
Fisher present. Member Hinsey?
Present.
Hinsey present. Vice Chair Hyland?
Present.
Hyland present. Chair Washburn? We were informed that Chair Washburn would not be able to attend today's meeting. Item number, I believe that there will be some potential agenda changes, but I can go through the approval of the minutes prior to that if you would like.
Sure, let's do that.
Item number 2.
Actually, Victor, let's take that in order. That should be number
Okay.
1, so let's do it.
I believe that there, regarding item number 3, the Ethics Commission policy discussion, Member Hepner was going to provide a presentation on that item, but he will not be arriving until later in the meeting. So there may be a need to take testimony from the Ethics Commission and delay the remainder of the hearing to later in the hearing. That item is also related to item number 5 regarding Dominique Mianchi against the Recreation Parks Department.
Yeah. Can we just quickly see if those two people are here?
Is there a representative from the Recreation and Parks Department here today?
I wouldn't expect them to be here this early, but okay. And I don't see Dominic here either. Okay.
Is there representatives from the Ethics Commission here?
All right, we can maybe push that back too then. Yeah. So just for the members of the public, and then I'll take public comment on this. Items 3 and 5 are somewhat linked. Our main person presenting on item 3, Member Hepner, won't be here till a little bit later, I think closer till 6, unfortunately, due to constraints. And we've been communicating with him all day on that. So what we're going to try and do is take the other items first, and I realize this throws things off a bit for the people who are here and people who are not here, but we just ask that you bear with us. Also, the member of the Ethics Commission may have to present their piece first, leave, and then we'll pick up the item again when Member Hepner is here. So that's kind of what we're contemplating right now. If there's any public comment on that.
This is public comment on agenda changes only.
So on agenda changes, Acting Chair Hyland, I would urge you that as soon as Member Hepner arrives, that you finish up whatever agenda item you're on and then move right back to what should be the order of this. I personally do not want to wade through 4 of Jason Grant Garza's complaints before we get to something more substantive. Thank you.
Thank you. Yeah, unfortunately, this all came up in the last couple of hours, so we're just kind of going with what we have. Any other public comment on agenda changes? Seeing none, public comment is closed. Mr. Clerk.
Item number 2, approval of minutes from the May 5th, 2011, May 18, 2011, May 24, 2011, June 28, 2011, July 26, 2011, August 23, 2011, September 27, 2011, October 25, 2011, November 29, 2011, December 14, 2011, and the September 23, 2014, and October 1, 2014 meeting minutes. Are there any corrections to be made by members of the task force?
Most of us were not at those. The only person, sorry.
Member Fisher?
I was going to say, the only person from those 2011 meetings was Chair Washburn, who's not even here, so I guess we're just kind of approving them on faith,
Right. Yes.
which I'm fine with.
Yeah, I think we've discussed this at some length. Member Pilpel?
Yeah, once again, I'm sorry I did not have the bandwidth to review these. I did just notice, though, on page 17 to 19, the template language about agendas is included here. That should not be in the minutes. The minutes is merely the text of the record of the meeting. So if we can strike those and try to make the format as consistent as possible, understanding that there's been some passage of time. But I will vote no since I haven't had a chance to review them. Thanks.
So, Mr. Clerk, can we take them as amended with Member Pilpel's suggestion, removing that template?
I believe that we currently only have, yes. We need a motion to approve as amended.
So moved.
Is there a second?
Second.
On that motion to approve the minutes as amended, Member Rummel?
Public comment?
Is there any public comment?
So for those of us who were born with a hearing loss, not speaking into your microphone is extremely disrespectful to the public. I didn't hear one word of what Mr. Pilpel said, not a word. Can anybody summarize what it was that he said?
I'll have the clerk summarize his changes as part of the motion.
Well, since these things are so old, you should pass them immediately. In fact, Member Fisher, this is a failure of the previous task force not to have approved them until 3 years later. You had all of 2012 and 2013 to have done so before now. This is really quite pathetic.
Any other public comment on the motion? And Mr. Clerk, if you could reread the motion for us, please.
The motion is to approve the minutes as amended with a correction to page 17 and 19 to remove the template language, to strike the template language. Is that correct, Mr. Pilpel?
Yeah.
17 and 19 of which minutes?
My pages are numbered through the packet for the entire packet for today. On that motion, Member Rummel.
Aye.
Rummel, aye. Member Winston.
Aye.
Winston, aye. Member Pilpel.
No.
Pilpel, no. Member David.
Aye.
Pilpel, aye. David, aye. Member Fisher.
Aye.
Fisher, aye. Member Hensy.
Aye.
Hensy, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The motion passes.
Hallelujah.
Item number 3, file number 14093, hearing, Ethics Commission policy discussion regarding Sunshine Ordinance Task Force referral.
Item number 4, you mean, Mr. Clerk?
Item number 4, hearing, Office of the Sheriff's request for reconsideration of Sunshine Ordinance Task Force order of determination regarding file number 14056, Jason Grant Garza against Ross Mercarimi, Paul Miyamoto, Kathy Gorwood, and Raymond Winters, Office of the Sheriff.
Good afternoon, members. My name is Mark Nico, appearing on behalf of the Sheriff's
One second,
Department.
Mr. Nico, 1 second. Is there any question of jurisdiction here, Mr. Clerk? We've already dispensed with that.
We do have jurisdiction over this matter. Just to summarize, the task force issued an order of determination on September the 26th, 2014. The Sheriff's Office submitted a request to reconsider our order of determination approximately 10 days after that order, which is within our time frame.
Okay. And what's the procedure we should follow here? Is there a...
There's no official procedure, but we can
Okay.
follow our standard procedure for hearings.
Okay.
If I don't foresee a problem
Okay.
with that.
And you have up to 5 minutes. Please say your name again.
Sure.
Since I interrupted you.
Thank you. Good afternoon. Mark Nico, NICCO. On behalf of the Sheriff's Department, the Sheriff's Department was represented at the hearing in this case. I was here as the representative at the first hearing of this case. And based upon the order of determination by the task force, the sheriff did file a notice or petition for reconsideration of the two determinations that this task force found the Sheriff's Department violating the Sunshine Ordinance. The two different violations are, the first one is 67.21A, which found us in violation of not providing Mr. Garza with video retention policies. The question with regard to that, in the request, as I mentioned in the petition for reconsideration, in my argument to this task force, and in my memorandum in support of the reconsideration, was that Mr. Garza's request was for records as they related to an incident of his arrest at San Francisco General Hospital on a specific date and time. With regard to that request, we were complete and timely in our response to him. The Sheriff's Department, although has access to video at the hospital, since we're the security there, we do not control or maintain the video equipment there. That is on contract through the hospital itself. However, I did learn through my investigation of this case that the video that Mr. Garza was requesting was no longer available. I learned that from hospital representatives. That information was made known to Mr. Garza and made known to this task force at the time I appeared. Based upon that, there were no video retention policies to share with Mr. Garza. Instead, I told him to please contact General Hospital for those, since they're under their control, the video policies. However, my understanding from the determination is that this task force found a violation of the Sunshine Ordinance because the Sheriff's Department did not provide Mr. Garza with retention policies for videos at other sheriff's facilities. And this, I believe, is an error of or beyond what Mr. Garza asked for. It was not relevant to his request, it overreaches his request, and was not known to the Sheriff's Department that that's what he was asking for. Therefore, I believe that the task force's decision with regard to that violation is beyond the facts and beyond the request of this case. And I'm asking on behalf of the Sheriff's Department to rescind or reconsider that decision. The second decision by the task force was in relationship to section number 67.29, the Sheriff's Department failure to properly maintain the Index to Records website. This is a jurisdictional issue. There was no complaint made by Mr. Garza or any other individual or agency that the Sheriff's Department maintenance of the Index to Records was a problem, or that there was any type of concern with regard to that. Basically, what I'm saying is that this task force does not have the ability that I'm aware of to just come up with a complaint sua sponte, without any type of notice, without any type of formal complaint procedure, find a complaint, bring in their own evidence at a hearing, and convict a department or agency of violating the Sunshine Ordinance when there's been no complaint and no evidence presented. The only evidence presented in that case, mind you, there's no complaint to begin with. The only evidence presented was a task force member or more going online, looking at the Index to Records during the hearing and saying that it wasn't up to date by the Sheriff's Department. That's not proper evidence. That wasn't submitted to this task force to look at or determine in that hearing. Therefore, I believe that this task force in this determination overreached its authority and jurisdiction in finding a violation pursuant to the Index of Records. I'm happy to answer any questions, if you have any, with regard to these arguments.
Thank you. I believe DCA Cola, did you have some comments on this this matter? No, there's no complainant. Actually, hold on one second. Mr. Clerk, should we give the complainant an opportunity to talk also?
I was going to...
Okay, my apologies. We'll take that later. Mr. Garza, if you'd like to say a few words.
Oh, I'd like to say a lot of words. First of all, I find it truly distasteful that, it's even being voiced for reconsideration. You guys are the judges. they have the ability that I have, if I don't like your decision, to, go to civil court. I think that that's what you guys should do, is have them go to civil court, just like, when you guys rule against people, in our favor, let's say, for example, what Mr. Grossman had to do, and take people to civil court to get the Sunshine Task Force, law enforced. Secondly, for him to get up here and to espouse, that you guys couldn't rule on the index of records, nowhere in the ordinance does it say that you guys can't find other violations. This is your job. Thirdly, when he got up and he said that, it was complete, complete. I never got the videos. As a matter of fact, I've still never even gotten the policies. Complete? What does that word mean? You're being bamboozled by lawyerese. You're being taken advantage of. This is the sheriff's department that, when I went to go follow up on the policies, I was never given an opportunity to speak with Mr. Nico, even though I have several videos on YouTube of me trying to follow up and do everything correctly. Oh, it's amazing how, the goalpost is being moved here. You guys are being told, oh, well, you can't do this, you can't do that, due process, et cetera, et cetera. All my due process was violated. I showed you the video of where I went in and, walked out in handcuffs, simply seeking my medical records. And, of course, naturally, I even asked when I was being detained at the sheriff's place there at San Francisco General, whether those videos that I was watching through the next cell were being recorded, and I was told yes. And then for them to say that they don't have the videos and they haven't even come up with the policies for retention? Oh, please, folks. Are you here to advocate for the citizen? Are you here to bend over backwards for people who've already been found guilty by you? Let them go to court. Just like you'd have us do when you guys make a mistake or an incorrect decision. Shall I bring up the Mr. Grossman case and the ethics and how you guys never get anything enforced in ethics and how much of a farce that is? As a matter of fact, I heard something, in the past about, maybe truncating the services for us serial litigators, i.e. somebody like me who's brought the Department of Public Health up repeatedly, and it's been repeatedly found in my favor, but yet the serial violators, the Department of Public Health, oh, well, maybe we should allow them to continue to break the law willy-nilly. And, speaking of breaking the law, remember what I told you guys about precedent. We're going to go all through this all over again for medical records because you guys don't set a precedent. So don't set a bad precedent here and bend over for the sheriff's department, who is only security there when my legal, medical, humane, and every other rights have been violated, and all I'm seeking is what I need to defend myself, to represent myself here at the Ministry of Sunshine, where apparently sunshine is very opaque. Depends on the interpretation of the law, who's given it, what fancy dress they're wearing, but certainly not for the citizen, because like I said, you can go to YouTube and you can see many times where I've tried to follow up with the sheriff's office and not been helped. As a matter of fact, I've been thwarted. So that's my piece on this. That's what I have to say. And, once again, you guys, do the right thing. And I'm a little upset that there aren't a full board here, because as far as I'm counting, there's 2, 4, 6, 7. The majority of 7, I believe, is 5, not 6, maybe 4. So once again, there should be 4 people ruling in my favor to determine this instead of, 6 that are required under another law that doesn't follow due process. Since we're talking about due process, and since that's what the sheriff's bringing up, I figure I might as well throw in my comments about how this is all set to fail and, how there's no accountability. And let me ask you one more specific question. How many ethics commission stuff that you've sent up has actually been, found in favor of? As a matter of fact, I believe it was the BAR that wrote an article that said it's 16 or 14 times that you guys have sent something up to ethics. It's been a failure. So I brought this up in the past. I'm glad I'm here to continue to speak the truth to, what I consider sycophants. But that's my opinion. Let's see the performance and let the public judge based on the performance or lack of it thereof.
Thank you, Mr. Garza. And May I just suggest that you keep a deferent tongue in your head this evening? We're going to be hearing a lot of your cases. The reason that we're hearing this case, I'm not asking a question, I'm just telling you.
I didn't hear what you said.
No,
A definite what?
You can just step aside and just listen. Be deferent to the people around you, including us.
What does that mean?
That means be respectful and polite.
Is it telling the truth?
I'm not asking you a question. This is a rhetorical statement, so don't answer.
Well, then I don't understand.
Don't worry about it.
How can I,
So this is the correct process for appealing an order determination, and we're going to get to the heart of that. But if you give us a chance to do the right thing, we'll be much more likely to keep an open mind. So please do.
And if I tell you that you failed in the past with the truth,
All right, that's enough. That's enough. Thank you. Thank you. Mr. Clerk, should we go with Mr. Cola's summary next?
Do you have anything to say?
I believe, I think there was an analysis that you did several weeks back when this first came up, if that rings a bell. So that'd be good, some good background, I think, on this.
Maybe. Yeah. I mean, essentially what this does boil down to is a due process issue. I think the task force could come up with any potential charges within the realm of possibility for a particular complaint, but then you'd have to consider whether or not, the 67.29, the failure to keep an index of records, whether or not spontaneously raising that issue during that particular meeting, if that would have affected the sheriff department. And who they sent to explain or to respond to that particular complaint. And again, regarding the other issue on the 67, I believe it was 2-1 issue. My recollection of that hearing was that the complainant did submit records or did submit some documents in support of his claim. And the testimony didn't really reflect the documents that he had. So I think moving forward, we should really put an emphasis on the actual tangible records that we have in support of all arguments in these cases. In particular, right now, I think both sides make compelling arguments, and I don't want to offer a ruling in either way or sway anyone's opinion on it. I think you should consider the evidence before you in this particular hearing and make your own determination.
I think in particular what I was referring to, DCA Cola, was more our process for reconsideration of order determination. What's required? Have those requirements been met? Is there any new evidence that justifies this, etc.? That's the angle I was looking at.
We don't really have a set out protocol for reconsidering a determination that we've issued at the moment. That being said, I don't think Robert's rules would forbid it. I think thus far treating it as if it's a normal complaint is an acceptable process, but it might be something we might want to consider as a bylaw amendment moving forward. I think we can move forward as long as we just keep in mind due process and affording both parties, a fair opportunity to present their case. But laying out an exact protocol in the bylaws in the future is something that I highly recommend.
Okay, no, I think that's something we have to do. I was under the understanding that evidence of new information would then allow a case to be reconsidered. That I thought was in our bylaws.
Did we hear any new information right now, though?
Let me open this up to the members of the task force. Member Pilpel?
I've been thinking about this a lot, along with being sick. You asked the right question, Acting Chair Harlan. I don't believe the bylaws speak to it, nor do I think that they need to. I think it's the complaint procedure. And Victor, if you can pull up the section of the complaint procedure that speaks to reconsideration, I'm trying to figure out what the standard is for reconsideration, because we haven't had a request for this in a while. I'm trying to figure out if the request meets the standard. So that's one area. The other area we touched upon a little bit here is this question of due process. I have an outstanding question in my mind about whether, frankly, any of our hearings are due process hearings, in that we hear complaints, we make determinations, we exercise certain powers, limited powers of the city in that regard, but we don't have any enforcement ability. We can't issue any disciplinary action or collect fines or do anything to enforce decisions that we make. We'll talk about that more as relates to the Ethics Commission. But if that's the case, I'm not sure if our hearings are actually due process hearings, and if that requires notice and the opportunity to respond and weighing of evidence and all of that. I don't know. And it may be that some of our hearings are, if we're considering a referral to ethics, and some don't. It's an interesting question, and it's one that I think we need to figure out. And I think Mr. Nico's arguments are interesting. I'm not sure where I go with them. And so I need to have a better understanding of both our standards for reconsideration and this question of whether due process is required for hearings. And then I'll
Okay, on that,
comment further.
I think the clerk, do you have that section, so you can just read it out to refresh our memory?
Yes, our complaint procedures state the following. Reconsideration of task force findings. Within 10 days of receipt of the order of determination, either the complainant or respondent may petition the Sunshine Ordinance Task Force for reconsideration only if information exists that was not available at the time of the hearing, and the petitioning party must present an offer of proof as to the new information.
That's pretty clear cut. Okay, thank you. Member David?
Is there any new information today that was not presented previously?
There are two issues. One is 67.29. There is not new evidence because my argument with regard to the task force finding on that case is based upon the evidence presented. So no, there is no new evidence with regard to that.
So I just want to try to understand your position. So what you're saying is that you do not feel that there was significant evidence to find a violation of 67.29 when the task force found that violation.
Correct.
Is that your position?
Correct. That finding was an error.
But there's no new evidence. You're just saying that's your position. And then you said there was a second point.
The second point is the 67.29 with regard to index of records. Mm-hmm. There was no evidence presented with regard to that issue.
Okay.
There's no new evidence because there's no evidence to even base that decision on. My concern with the finding of that violation is that the task force was beyond its authority and jurisdiction in even considering that violation because it was not a valid complaint and because there was no evidence presented on it.
Yeah. So in my opinion, you very possibly could be correct on both points, but the way that I just heard the reading of our rules as to reconsider, that neither of the points that you're making, which could be 100% correct, would allow us as a task force to rehear and reconsider that case. And so, I think I'm going to vote to not rehear this, and that, as Mr. Garza said, you obviously, and the Sheriff's Department has the right to make that argument to the next level.
I appreciate that.
Yeah.
And again, I want to reiterate that this is a concern with regard to following your rules. I understand that. But let's be consistent in how those rules are enforced. I've pointed out in my argument that this task force neglected many of its rules in order to find these decisions. And because of that, we're here for reconsideration.
Yeah, no, and I want to also be clear that I think that is a very fair argument. And, I wish it was one that we would have considered at the time of the original case. But I think that, to me, there's a much higher bar that needs to be reached to reconsider a case. Right? At the original case, I think that argument would have been made at the time. Then we might have been able to address it at the time. But at this point, I don't want to set a precedent that without new evidence being presented, that we're going to rehear cases. once again, we as a task force could have absolutely been incorrect in finding that violation. That's not what I'm arguing here. What I'm arguing is that what we are here to consider is the reconsideration of the case that we've already decided. And to me, it doesn't meet that standard because there is no new evidence to be presented.
Thank you, Member David.
Yeah.
Member Nico, in many cases, the task force is within its purview to find violations above and beyond what was brought by the original complainant. Many times the complainant doesn't know the scope of what else is within the Sunshine Law. So many times we've gone past what the original complaint was because we're here to enforce Sunshine, not particular, one plaintiff's case against another. That is our charter. And as far as the evidence not being there about the index of records, that's because the index of records was not presented to Mr. Garza, and that would have been something that would have been, if there had been further information on that, so that argument kind of falls as well. So I'm afraid I'm leaning towards Member David's position on this. I think, new information and proof within that 10-day period would have certainly held water as far as a reconsideration, but I don't see that in this case.
I'd like to address one concern I have with regard to that rationale.
Just 1 second. I'm going to give, we're going to talk a little bit more. Is there any more discussion in the task force? And then I'm going to give both sides a chance to summarize. I said both sides to summarize. Member Pilpel?
So, Mr. Nico, you don't have to answer this. If the task force denies your request for reconsideration, are you at this point likely to respond and appear at the committee meeting, or are you considering an intergovernmental, what do you call it, intragovernmental action against the task force on this question of authority?
That hasn't been decided yet, so I couldn't answer that.
Okay. I don't know how big a deal this is or how big a deal this could be. I would rather that we try to figure this out and avoid litigation if that's a possibility here. So I'm kind of torn on this, and I would still like to hear more from DCA Cola on this question of whether due process attaches to our hearings normally. I'm still unclear about that. And for me, a lot of this decision turns on that.
Personally, I'm of the school of thought that due process does attach to administrative hearings. I think if a party to a complaint here were to actually file a court action to overturn something in the superior court, that would be the standard. They would say were the parties to that complaint afforded due process in their administrative hearing. And because of that, I think we should hold ourselves to that standard.
Well, then in response, if you go with that line of thinking, then due process in an administrative hearing requires charges and the opportunity to rebut and present evidence, and that the decision makers have to consider the evidence. As Nico suggested, an additional charge brought, what's the term, sua sponte, doesn't offer the respondent in this case the opportunity to present facts and evidence to rebut.
Well, it seems as if in order to afford more due process, there needs to be a bylaw amendment that allows for a more broad interpretation of what we can reconsider. As it is right now, there's no procedure for us to hold a hearing unless there's new evidence.
Member David?
Yeah, I want to somewhat echo what DCA Cole is saying, is that I think that what this case, the best outcome of this case is that we add to the bylaws to make it so that due process, a full due process is something that, or a lack of full due process is something we can consider in rehearing a case. But until we change that bylaw, I just don't see, I don't think we can, make up bylaws on the fly as we go. And it seems pretty clear that a plain reading of the rehearing rules does not allow for a rehearing of this case. And so I think it's an important incumbent upon us to change those bylaws. But until that is done, I really don't see what we can do.
Is there any other discussion amongst members? Anybody else? Respondent, you have up to 3 minutes to summarize your position.
Well, I just have to laugh about due process. I believe it was Mr. Papel who said that, this committee doesn't afford due process. I believe, DCA spoke to the fact that, administrative hearings don't afford due process. Speaking of due process and changing the bylaws, there's 7 of you here. I need 6 of you to vote in my favor to win. How is that due process? Well, I've only been bringing it up for, 10 years now? Isn't it amazing that when the other side speaks, you instantly bow over for their due process concerns? But when us, the citizens, the violated citizens speak, that doesn't seem to matter, at all. Also, there is new information. I still have not gotten the policies. Wow. Talk about due process for an IDR. The Ministry of Sunshine can't even get that enforced. Sorry, I am paying you the utmost deference in speaking the whole truth and nothing but the truth, Your Honor. So help me God. So, it is not I who am the failure here. It is the fact that you guys are bending over backwards for the city, being a shill for them, and violating all the citizens' rights when it comes to their due process, what they need to get to prove their cases and everything else. You go up against the Sheriff's Department, which can't even walk me across the street to get my medical care, which can't provide police services at San Francisco General because they're just security, which, can't find a dead woman in a hallway. I mean, you guys, how much longer does this have to go on? And mind you, the next case is going to be about my medical records. And mind you, they're going to get up and say, well, they're not.
Mr. Garza, I'm going to interrupt you, and we can put
Please.
time back on. You are summarizing this case only, not anything else. Please stick to that.
So, like I said, when it comes to due process, I still haven't even received the policies, much less the videos. So,
Thank you.
I still have a minute left, but if you want to cut me short, please go right ahead.
Mr. Garza, do you understand that in this particular case, it would take 6 votes to rule against you, not for you, in this case? So when you say that...
That's still not due process. It should only take 4 out of 7.
No,
we're talking
my
about
point
due
is-
process.
Okay, thank
That
you.
was what it was all about.
I just want to make sure you understand.
Mr. Nico, you have up
The
to 3
principle
minutes.
of due process, yes.
Thank you. Thank you. Mr. Nico?
I understand that the procedures for the task force indicate that a reconsideration can only be obtained with the submission of new evidence. However, I would indicate that, based on this discussion, that threshold is not very realistic and not very efficient with regard to the arguments of this case. I can't talk to other cases. With regard to the first finding of whether or not the Sheriff's Department was in violation of the ordinance by not providing information that we had no idea Mr. Garza was asking for, should not require new evidence. If this task force made an error in its finding, in its arguments, in its determination, it should be able to reconsider that upon proper notice and petition, which it has. More importantly, with regard to the 67.29 index to records, there was no evidence presented at all to support that finding. The argument whether or not this task force can go to different violations based upon the evidence presented and based upon the arguments presented that are before the task force is one argument that I'm not addressing right now. But whether this task force can look at evidence that is not submitted in the case on its own motion, on its own accord, without any type of sharing with the parties, I think is beyond due process. It is not admissible evidence. And if this task force makes a finding that is not based upon the evidence before it, it is wrong and should be open to reconsideration. Therefore, my motion, my petition, and the memorandum behind it urges this task force to find that there's error in both determinations and rescind those findings.
Thank you. Member Papel?
So one more question from DCA Cola. So if you are opining today that at least on this matter, that this is a due process hearing. Does that mean that Member Heinze, who wasn't a member of the task force at the time, needs to review the record from the underlying hearing, and that Member Winston, who was absent for the underlying hearing, also needs to listen to the tape and view the record? Is that a required element of the due process that you're taking a position in support of? I mean, it's tricky.
Well, I think generally, a body such as a task force that's going to be reviewing a hearing and afford the parties to the hearing due process should be informed on the issues. So I'm inclined to say yes, but I don't want to offer that as my official opinion at the moment. I'd have to research this.
I think regardless, we're operating within the confines of what we do have in our bylaws, and I urge the task force members to focus on that at this point. I think, further fleshed out complaint procedures might and probably should consider these matters, but I think as we stand now, I think it's fairly clear cut, and this also gives Mr. Nico the opportunity down the road to come back when those procedures have changed and have this reconsidered. So I think right now, do we need a motion on this? Do we not need a motion on this? How will this work, Mr. Clerk?
There would need to be a motion to reconsider the item. There being no motion, the matter would be concluded.
Okay. Do I hear a motion to reconsider?
Public comment.
Thank you.
Oh, sorry. Motion first.
Yeah. So do I hear a motion to reconsider this case?
I'll make a motion that we grant the request for reconsideration from the Office of the Sheriff.
Is there a second? There is no second. Member Kola or DCA Kola?
Just an idea. Perhaps the task force can offer to continue this matter until there's an amendment to the bylaws.
Thank you.
Member
Rummel?
So regarding the second issue, the due process issue, I think the point is well taken that we should be consistent in our rulings and should rule only on the facts that are presented. We do that all the time where we find a violation of something that a complainant's hasn't come in complaining about. And I think it's a little tricky for the reason that you laid out. Complainants don't always necessarily know the full breadth of the ordinance or necessarily what they should complain about. And this isn't a court either, so it's a little different, which is perhaps a long way of saying we would need to do more to our procedures than just amend our procedures for reconsideration, but we would also need to amend how we consider things in the first place.
Process
right?
and the standard on the...
Right, because we do what he's complaining about all the time. And I think I tend to agree. I think it's a problem. I don't know that the right of due process necessarily attaches, but I think principles of due process should be applied, and we should try to be as consistent as possible, as often as possible, and afford parties as much opportunity, to respond as possible. But given all that, I would be inclined, to not reconsider it at this point. Oh, and I had one other thing regarding the first part, which was the Office of the Sheriff's apparent belief that it has to provide every video retention policy for every facility. I don't remember that being part of our determination. My understanding was if there is an overriding policy data retention policy, video retention policy, that should be provided, not that each facility has to provide one. I tend to agree that that's not within a fair interpretation of the request, but the overriding policy, I think, is certainly within the request.
If it exists.
Yeah, if it exists.
So having heard that, I mean, we can certainly continue this. I'm not sure how much help that will be to Mr. Nico. But any thoughts on that, task force? I mean, is a continuance, maybe technically that's the right thing to do, but is it really going to, who knows when those bylaws will get changed, get voted on, and get enacted? Does the Sheriff's Department not have the opportunity to then, resurrect this case or make a petition for reconsideration at that point? If anybody has input on that. This is just more mechanics here I'm discussing.
I tend to think at this point, given the tenor of the discussion, that we should pursue a change to not the bylaws, but the complaint procedures to better clarify at least the standard for reconsideration. And I think just new evidence is insufficient. I'm thinking about manifest injustice. I don't know about new arguments, but I want to think about that. And I want to think about this question of being able to respond to charges and how all that works. On the merits, however, in thinking about it further, I don't actually think, frankly, that this case is of such great import that it should live much longer. So I'm inclined not to move to continue and to suggest that the Sheriff's Department just respond to the order, attend the next hearing, and we'll see what happens at the committee. Frankly, one can make a big deal out of everything. I'm not sure that this is one over which everything should be made. So that's my thinking, subject to public comment.
And if this matter is closed, where would it then go? You're suggesting it would go back to?
We've issued an order and asked the sheriff to appear at EOT, and I think that was going to happen on Monday. And
Right.
We can discuss then whether they have this policy that Member Rimmel referred to, and the status of their index of records. And we can argue then about whether it was good and timely or not, and let it go where it goes.
Fair enough. Okay. So I think this would be a good time to take public comment on this.
Sorry, my knee gave out on me. I have to agree with Mr. Nico. You have the same issue before you with the Ethics Commission on their policies. They wonder how you tag things on between your motion, your order of determination, and then the referral letter. You have the same issue here. I think the task force is within its rights while you're considering a case and it's under discussion by the members of the task force to add other violations by citing them, by citing the applicable paragraph numbers, just so long as they apply somehow to the case at hand. I have to agree with Mr. Nico that this whole index to records thing had nothing to do with the complaint, and that it should not have been added at your discretion in the order of determination. I'm feeling the same way regarding the video retention policy. If the video retention policy is actually an obligation of SFGH and not the Sheriff's Office, you guys should have limited adding that to the order of determination, knowing that the complaint was against the Sheriff's Department. You should not have put in there a retention policy for SFGH. So I would urge you to entertain a motion to table this issue and place on your amendments committee agenda an agenda item to quickly revise your complaint procedures to straighten them out. But I would not just dismiss this request for reconsideration, because if the reconsideration rationale is, as you would admit, too narrow and should be broadened, you shouldn't just throw out the first reconsideration request that comes your way.
Thank you.
Good afternoon, Task Force members. Thomas Piccirillo. I am in complete agreement with your inaction on the motion for reconsideration. Your bylaws are clear. You have two thresholds. He has to file the motion within 10 days, and there has to be new evidence. But new evidence when they are acting with due diligence. So it's pretty easy denial of the motion of reconsideration. The concept of tabling this or staying this until you amend your bylaws, then you would certainly be depriving Mr. Garza of due process. You're changing the rules after you've already litigated a case. And certainly you're all in favor of not depriving due process. So a suggestion to you so that the next motion of consideration doesn't have to consume 1 hour is your administrator, when he receives a motion for reconsideration, can ask the moving party, did you file in 10 days, and what is your new evidence? If the new evidence isn't presented to the administrator, he shouldn't put it on your agenda, and you don't need to discuss for 1 hour a motion for consideration that was without merit. Now, finally, there was some criticism of your protocol regarding motion for reconsideration. That's almost right on point with the judicial basis for filing motions of consideration in Superior Court, as Mr. Romo would tell you. A motion of consideration, you have to show newly discovered evidence, acting due diligently, or fraudulent concealment of evidence by the other side. So your bylaw is actually very much in compliance to motion for consideration in Superior Court. Thank you.
Thank you. Is there any more public comment on this item? Seeing none, public comment is closed. Is there a motion? Seeing none? I think the cleanest way is just to well, Mr. Clerk, what would you recommend?
There being no motion, the request is concluded and no action is going to be taken.
Thank you. Okay.
Just to note that the original file is scheduled before the Education Outreach and Training Committee for this coming Monday. That is for consideration of the provision of information regarding the department's procedure for maintaining the index of records only.
Index records. Okay.
I'd like to go backwards on the agenda to item number 3. I believe the Ethics Commission representative is here at this time.
Okay.
Item number 3, file number 14093, hearing, Ethics Commission poly discussion regarding Sunshine Ordinance Task Force referrals.
Okay.
I don't know if the representative was here at the beginning of the meeting, but Mr. Hepner will not be here until later in the meeting. We would like to take any testimony you'd like to provide and then continue this item to later in the meeting.
Actually, I'd like to ask, and pronounce your name for me again.
Jesse Maynardi.
Maynardi, that's right.
Maynardi.
Maynardi. I think Mr. Hepner is going to be here at 6. It would, in an ideal world, he would love to hear what you have to say, and as he's somewhat point on this, and then pass it on to Chair Washburn, who'll be attending your next meeting. Would it be too much to ask, wait another hour, if you'd rather say your piece and move on?
First of all, let me apologize for not being here earlier. So
No, that's
sorry about
okay.
that. I think, unfortunately, I won't be able to stay till 6. I have 2 young kids, and unfortunately, I have to be
I
home to
understand.
help with them. And quite frankly, I wasn't necessarily going to say a whole lot. Maybe just give a little more context, add 1 or 2 more things to let you know what's happened since the last time I was here. And really, the only thing that has happened since that time is that somebody had a suggestion that we take this memo, which I think has been distributed to all you folks, and distribute it out through the city to department heads as well to get feedback and open the process up to everyone. We haven't received any comment from anybody yet, but certainly wanted to let everybody know this is what we're doing, all interested parties. So that's pretty much it. I think I may have briefed you guys the last time I was here, but I'm certainly willing to kind of take any questions or engage in a dialogue. We hope this is an open process and welcome any comments and input. And I'm sorry, last thing is, so there will be a final version of this memo which will incorporate any and all sort of comments or, well, not all, because there could be a lot, but certainly any comments we think that are relevant. We did give a draft of this memo, the same one that you guys got, to our commissioners at their last meeting. So telling them that we'd be addressing this issue on November 24th and that they would, if they're interested, they could take a look at the issues as we presented them already.
Okay. And I believe Member Washburn and perhaps Member Hepner will be at that meeting as well to further discuss.
I'll probably be there too.
Right. Okay.
And I was able to speak with them at the meeting that they held.
Right.
I attended that committee meeting.
Those complaints. Member Ronald?
So I just had a quick question for you about the first issue, the inconsistent referrals, and the recommendation. So the option 4 recommendation was, or you all recommended option 4. And the part I had a question about, you know what I'm, okay. So the part I had a question about was in Chapter 2 matters, the commission should shift the burden back to the complainant for any additional violations and respondents in the referral letter. Did that mean for anything that the Ethics Commission considered to be inconsistent with the referral, they would shift the burden back, or was it for the entire complaint?
I think the idea was anything that was added in the referral letter that maybe wasn't part of the order of determination. So if there were additional,
And then the current burden, you'd keep the current burden for anything that was in the referral and in the complaint?
I would think so. Procedurally it is a bit of an issue. I guess we would have to sort of split it up into 2 different kind of decision points when it was heard. But as hopefully has been made clear in the memo is just, I was just here at your last matter, you guys are sort of wrestling with some of these procedural issues right here, and then there's this sort of how that fits in with what we do in reviewing it.
No, I think the inconsistency is more a fault of ours than than yours, and struggling to deal with it is obviously a product of our inconsistencies. So.
Sure. It's tough.
Okay. Thanks.
Sure.
Member Pilpel?
I'm just noticing on page 121 of the packet, page 6 of the memo, there's a nice little footnote 9 that the city attorney has advised that a respondent's due process rights are not implicated by the task force hearings, given that the respondent is only subject to reputational harm. See Paul v. Davis, blah, blah, blah. Again, Deputy City Attorney Cola, can you take a look at that? I mean, it sounds like what's referenced here is inconsistent with the advice that you gave us earlier. Thanks. I guess to Mr. Minority, and we've certainly talked at length about the memo and these underlying issues. I guess one of the things that I continue to struggle with, a lot of things I struggle we all know that. Is how much is a department head responsible for their subordinate employees' actions, whether they know or don't know? And, your commission has ruled different ways on that and may continue to do so. Do you care to give some thought to that and perhaps how that affects or might affect our proceedings as relates to a willful violation or not, and then how that gets to Chapter 2 and Chapter 3?
Sure. Well, we tried to, as Member Popel has said, that our commission has come out two ways on this, and there has been a recent case where there was a finding of a non-willful violation on the part of a department head for actions taken not by him but by his staff. And that was a very sort of factually based determination. And so, as Member Popel has said, because we've come out different ways, what we're trying to do with all of this is establish certain rules or procedures or at least criteria so that we can try to be consistent and that the public and city department heads, other interested parties can rely on us to be consistent in that matter. So here, I think we broke it up in terms of factors that might be considered for a finding of a non-willful violation, which would, have to do with sort of whether there was sort of a decent policy with respect to responding to records requests, sort of the proximity of the person responding in terms of the chain of command to the department head, that sort of thing. And then for a willful violation, though, we would want it sort of to be a little bit more so that there'd have to be some involvement, knowledge, that sort of thing, to find a willful violation. And so that's set out in option 2 and 3, 2 on page 8 and 9. Mm-hmm. So 8 deals with option 2 rather deals with non-willful violations, and option 3 deals with willful violations.
And just my last question, I think this is at page 6 and the top of page 7. On the issue of detailed findings or the level of detail that you would hope or request the task force to transmit in connection with a referral. I don't know if you've had a chance to look at the draft document related to the Mayanki matter, but that was just my attempt to try to bring some additional findings. I'm not speaking to the merits of that. We'll talk about that later. But is that the kind of additional detail that you were hoping to get in support of either referrals generally or a referral that for which you don't have enough information to go on?
Sure. I mean, it was very well written and not surprising. And without, as you said, talking about the merits, that was, if I recall correctly, sort of an analysis, a recitation of the facts, that sort of thing. I mean, that's one way to do it. There are other ways where you have actual, a list, enumerated list of factual findings, enumerated list of conclusions of law, that sort of thing. But, I mean, just more information, the better. As you know, with a Chapter 3 hearing, which is about willful violations for certain high-level officials, we do have in our procedures that we're going to take a look at it again. Our staff will look into it. But, with the Chapter 2, we're according deference to the task force, and so we're not doing any sort of investigation. So it certainly would be helpful to have sort of things to go on.
So particularly under Chapter 2, where deference is afforded to the task force, but even with respect to Chapter 3,
sure, yeah, definitely,
the more useful information, the better. I'm done. Thanks.
Okay. Any other members? Mr. Maynard, anything else to add based on?
Not at all.
Okay. Again, thanks for these efforts. We'll hopefully get some more discussion tonight, and we'll see you on the 24th.
Okay. Thanks very much.
Thank you.
You want to take public comment now, or wait until we hear?
The clerk, is Ms. Gong here? She is here. Okay. And I understand you have to be somewhere at 6. I'd like to have had Mr. Hepner here for this, but
I think on the item 5,
okay.
I can handle it. I don't
right.
think we're going to act. I think we'll continue it. So first, can we continue discussion on item 3 to later in the meeting? Till Member
Yes.
Hepner comes?
Yeah, so let's
And then
continue
let's-
let's continue number 3, Mr. Clerk, and then move to item 5.
Item 5,
Right.
file number 12058, complaint filed by Dominique Mayagi against Recreation and Park for allegedly failing to provide records requested pertaining to birthing contracts between the city and county of San Francisco and slip holders. The Sunshine Ordinance Task Force will consider and determine how to proceed with the Ethics Commission referral of file number 12058 back to the Sunshine Ordinance Task Force and possible re-referral to the Ethics Commission.
Shall I?
Do we need to determine jurisdiction?
No, the jurisdiction was found in previous hearings.
Okay. Is complainant here? Doesn't need to be. I don't think. Ms. Gong, would you like to approach? Sure, jump in. Go ahead. Do you want to hear from Ms. Gong? No, it's good.
It's probably better in the... Yeah, if I
Get the summary first.
Yeah.
We're going to do a quick summary first, so just hold on.
sit back down.
Yeah, hold on one second.
Okay, so on this matter, we heard the item a number of times before. It was sent back from the Ethics Commission for further factual information. I made a stab. I'm not claiming that it's perfect at all, but it was an attempt to draft a beefed-up referral letter back to Ethics and to provide additional findings. Again, I don't think that these are perfect or complete. I hope to have some discussion about them tonight. I hope in general terms that we continue this matter and don't make a final decision on this tonight for a couple of reasons, in part because Chair Washburn isn't here, and she may have thoughts and was definitely a part of this over the last couple of years, and in part because the Ethics Commission policy that we just talked about, I think, may have some effect on how this is handled. And given that this has been kicking around for some time, I don't think that there's some pressing timeliness issue to move it at this time. So I think we're better off having some policy discussion about the underlying matter, the procedures, maybe the department's position that we'll hear from in a moment, but not take final action on this tonight. That's my intro, and I can speak further after we've heard from the department.
Okay.
Does that work?
Yep. Ms. Gong, do you have anything you'd like to tell us or present to us? Go ahead. This is your opportunity to talk.
Good evening. I wanted to add some additional comments, 3 main points. First, there seems to be confusion about the purpose of the Ethics Commission referral back to the SOTF, which states only that the Ethics Commission is seeking further factual information because the Ethics Commission could not determine whether Phil Ginsburg was the properly named respondent. If the Ethics Commission is asking the SOTF to make factual findings about how and whether Mr. Ginsburg participated in the RPD decisions about Mr. Mayonki's document request and SOTF complaint, I can provide the following information on that question. As the RPD staff person responsible for responding to public records requests, I do not report to Mr. Ginsburg, and I did not discuss Mr. Mayonki's request or SOTF complaint with Mr. Ginsburg. Mr. Ginsburg's September 3rd, 2014 letter, which is on pages 165 and 166 of today's record, confirms that he was not personally involved in the response to Mr. Maionki's request and complaint, though he supports the decisions I made with my supervisors. I have a copy of that if you need that. Secondly, some of the materials in your packet today in your packet for today contain representations about RPD actions and positions that are not correct. I want to correct the record. In the draft SOTF findings on page 147, the last paragraph entitled Background Facts states, quote, the task force was informed that RPD considers rental agreements for boat slips to be contracts and does not redact personal contact information when disclosing copies of such rental agreements, but considers waiting list applications not to be contracts and thus does not redact personal contract information when disclosing copies of such waiting list applications. This statement is not accurate, and the interpretation of this alleged department position on page 148, third paragraph, is thus founded on a misunderstanding. If a document in RPD files contains personal home addresses and personal telephone numbers, and those pieces of personal information do not themselves shed any light on the operations of government, it is RPD practice to redact the personal information to protect the individual's constitutional privacy rights. Those privacy rights of our customers and users do not depend on what title is on a document. If RPD previously released a rental agreement without redacting the home address and personal telephone numbers, that was an error. Looking back in the record, when RPD sent its original December 19th, 2012 letter to the Sunshine Ordinance Task Force, we stated on page 5 that even if applications were contracts, home addresses and personal telephone numbers would be redacted to protect privacy rights. Third, we understand that the SOTF seems to disagree with the long-standing city attorney advice about redacting personal information public records. On page 148, the draft SOTF findings concludes that my initial decision to redact documents based on advice from our legal counsel and long-standing practice is not a willful violation of the Sunshine Ordinance. RPD agrees. It then states, quote, given the prolonged nature of this case and the department's unwillingness to consider disclosure or any other alternative to non-disclosure, the task force further finds the violation on Mr. Ginsburg's part to be willful in nature, unquote. First, 2 of the 5 individuals Mr. Maionki seeks to contact provided business telephone numbers on their applications. He is free to use that information to make contact with them. We made very narrow redactions. This is our alternative to non-disclosure. As an official representative of RPD, I have personally responded promptly to all requests from Mr. Maionki and the SOTF. Nothing in the long proceedings has changed our analysis of the facts or changed the city attorney's legal advice about the privacy rights of our customers. Where the facts and the advice from our legal counsel have not changed, we do not understand how maintaining a consistent position over time can convert the department's actions into a willful violation of the Sunshine Ordinance by the department head.
Thank you. And do you have a written copy of that for the records? Okay, great. Thank you. Member Pilpel?
Well, it's nice to know that somebody reads what I write. That's cool. All right. Well, if I got it wrong, I will take another whack at it. My understanding was that we were so informed that rental agreements are public and are considered contracts, I believe, under 67.24E, one of the sub-provisions in 24E. I had a long internal debate with myself about this question of whether it's willful, so I included that language about given the prolonged nature, but I have some reservations about that, particularly given that ethics would have to investigate the matter. If we allege that it's a non-willful violation, then the presumption is with the task force, and there is no further investigation, and it's up to the department head to rebut the matter at the Ethics Commission. A couple other things that I'm thinking about here. As I understand it, the current practice of the Board of Supervisors with regard to communications, general communications, are that they go on the communications log, the so-called C pages, and there's a notice that any personal contact information provided will not be redacted and will be disclosed. So it just seems to me that it's an odd circumstance that someone who sends a letter to the Board of Supervisors with their home address and potentially phone number saying either I love the Airbnb law and you should pass it, or I hate the Airbnb law and you should not pass it, will have their personal contact information released, available, and in fact on the web, and someone who has a rental agreement or a contract with the city for their large yacht in the Marina Yacht Harbor would not have their contact information available. That seems to me an odd circumstance at best. Just because one agency of government does it one way doesn't mean that all should follow suit. But in the same way, I just think we reviewed this matter in great detail and looked at the privacy balancing and found that in this case we just disagreed with the privacy balancing that the department did. And, you know, again, we don't have to make that a willful violation. We can just refer that back and say that it was a non-willful violation, that it was just a disagreement among governments. There was that. There was some other...
Just to chime in, Member Pilko,
Yeah.
from that case, I remember, I think it was Mr. Mayanchi who said that, you know, accepted applications that become contracts, and therefore the expectation of privacy is gone at that point. I think, however, because we did not have a knowledgeable representative from that department at the time, and this is exactly why we need to have those people at the time during the original cases to refute that. I'm glad they're bringing it up now, but that certainly is something worth looking into. But yeah. I remember that, and I remember that sounding very reasonable at the time, and thus the discrepancy, and that was the whole linchpin of his argument that convinced us that they had failed to provide this information.
And I assume that Mr. Mayanchi was advised of this hearing? Victor?
Yes.
And isn't here. The other thing that occurred to me, I recall when this matter was heard at the Ethics Commission, Mr. Ginsburg was not there. I think something about the kid in camp or something. And Ms. Ballard was there, who I believe is Ms. Gong's supervisor, and the harbor master, whose name I forget now. And I believe in the testimony before the Ethics Commission, either Ms. Ballard or the harbor master said that either as a result of Mr. Mayanchi's allegation or on their own, the department conducted an investigation of the matter. And what wasn't represented at the commission was whether or not there were written records from that investigation and whether any records from that investigation, redacted or not, could be provided to Mr. Mayanchi. It seems to me that one of the ways this potentially could get resolved is if the department did conduct that investigation, if they would provide that to Mr. Mayanchi, that might address his concerns. So, Ms. Gong, do you know anything about that investigation that Ms. Ballard or the harbor master referenced at the Ethics Commission meeting?
She's shaking her head. That's a no. Okay.
Could you see about that and advise the task force in writing, assuming that we continue this matter further? Whether, and in particular, the question is whether there were whether there was some investigation that was referred to, whether there are written records related to that, and whether those written records, whether redacted or unredacted, could be provided to Mr. Mayanchi. I don't think the task force is interested in seeing the investigation. I certainly don't need to see it. I just want to know if it could be provided to Mr. Maionchi. Fair enough?
Fair enough. I think at this point we should probably continue this.
Public comment?
Yeah, but I'm just want to see if there's any more discussion from members. So I'd like to take public comment on this with the thought that we will continue this. Member Nee? I'll give your knee a rest.
Good afternoon, task force members. Richard Nee. I was on the task force when the Maionchi hearing took place, and there are some things that I think might help inform your discussion and how to move forward on this. With respect to whether the personal information should be redacted or not, the task force has consistently held that the default policy should be disclosure unless under very special circumstances. And those opinions, those rulings by the task force have included votes in which voting member attorneys participated. So when the Recreation, Park, or any other department says, well, we were acting under city attorney's advice, that's the city attorney's advice with all due respect to Deputy City Attorney Cola and all other members of the city attorney's office. That is not law. It is advice, nothing more. Second thing, during the hearing, the task force pointedly asked Ms. Gong if the people listed on the contracts or on the applications had been asked if they wanted opt-in or opt-out on their personal information disclosure. We were informed no, they had not been approached on that. We asked if the Recreation and Park Department had any reason to believe that disclosure of the personal information would put any of the members, any of the people whose information was being disclosed in any kind of personal danger. The response we got was, no, they had not checked with any of the people, and they had no outward reason to believe that there was any danger that would be posed. Given that, I think that the violation here was very definitely willful. There was an order of determination. The order of determination was not complied with. Willful.
Thank you, Member Nee. Ex-Member Nee. Mr. Burnett-Shaw.
Thank you. It's a shame Chair Washburn is not here. She explicitly put this on the agenda, indicating that it would not be re-adjudicated, and what I'm hearing is re-adjudication all over the place. As far as I'm concerned, when ethics sent this back to you for further factual information, they did not ask you to wait to submit them further factual information until you get done discussing their new policies about sunshine referrals. I don't think you should continue this item. I told you before, I've testified to you before. You should send the matter right back to them and tell them that it's in their ball court. They ruled two different cases, the Maionchi case and the Ringel case, letting Ginsburg off the hook, but hanging planning director Rahane. They have to decide why they held one standard to one department and a different standard to another department, and that does not hinge on any further factual information about Maionchi's case. I think you should just make a motion and send the thing back to them that you don't have any further factual information, because whatever it is that Mr. Pilpul wrote, and I'm wondering, Mr. Young, if he has something attached to tonight's agenda about additional information on Ginsburg, or whether that was somehow sent to the Ethics Commission for comment without it having been cleared by you guys. Did Mr. Pilpel submit something to ethics about this already that they're aware of? Providing additional information that you guys did not take a vote on whether to send back? What's the answer? Did you or did you not?
The administrator does not respond to public comment.
This is really getting to be outrageous. You guys are starting to violate all sorts of your own processes.
If I may respond, my understanding is this is a draft that we're discussing in response to the
Should
Ethics
not
Commission.
continue this item. You should just send it back. Make a decision tonight and be done with it.
Thank you. Is there any other public comment on this item?
Thomas Piccirillo. I would agree with the last two speakers. You should raise a motion and send this back to ethics. You're going to be, if you don't, you're going to be spinning your wheels on many, many cases because ethics doesn't agree with you. Now you're going to rehear these cases. I mean, you made a decision. No, hopefully, it was the right decision. But that was your decision, and you shouldn't allow ethics to tell you to relitigate your cases. Regarding public comment and not, having task force members respond to public comment, there is nothing in your bylaws, nothing in the Article 67 that precludes you from giving people who are giving public comment feedback as to what they're saying. So if you don't want to speak with us, that's fine, but there's no preclusion that says you can't do that. So what I'm suggesting to you is just send it back to ethics. Ethics has a history. It has a sunshine, not friendliness to it. So I don't think you should allow them to dictate to you whether or not your decisions or your orders of determination have any validity. Thank you.
Well, unfortunately, I'm here for public comment on this issue because, all I hear is about you sending stuff to ethics. Well, I can tell you in the last 14 years or 10 years that you've sent things to ethics, I believe it was 14 times or 16 times, the Ethics Commission has not found in your favor. The prior speaker said that ethics doesn't work with you, doesn't, basically, throws everything you send out. So let me see if I understand this right. 10 years of dealing with an agency that doesn't help or support you, and yet you're going to them for approval. Are you guys like, the child seeking love from the parent? I don't understand this because apparently the parent is wrong. And, the children are still running around seeking approval. Well, you're never going to get it because the way that this city is set up from a due process standpoint and every other standpoint, it's to screw the citizens when they seek sunshine. It's to shut you guys down like they did, during the nuclear winter where you were closed for 6 months because you didn't have a disabled person on there, and you screwed all of us because, those of us who had complaints couldn't get it heard timely, which of course violated our due process. But, the image that you portray, wanting to be helpful, your hands tied, ineffectual, the Ethics Commission doing the wrong thing. With people with common sense, it just doesn't wash. As a matter of fact, I told the prior task force that what you guys ought to do is step down. Refuse to hear cases until you're granted power. But until you are granted power, all you're doing is just prolonging our agony, inflicting more pain, more harm, everything else. Because without power, you're useless. And I've been coming here for 10 years about medical cases, violations, et cetera, which have been found in my favor repeatedly. But the serial violators, guess what? Department of Public Health will be up today, once again, spewing, stuff about how medical records aren't public records. Once again, we'll have to recreate the wheel because there'll be no precedent set. If you do find in my favor, you'll send it up to ethics, which of course will, not listen to you guys and just send it back down. Children, I think it's time for you guys to grow up and realize that, the procedure not only does not work, it's rigged. You guys are the Judas goats, the people who are set there to fail and to be made the laughing stock, because that's exactly what you are, a laughing stock. I would suggest that you withdraw, hear no more cases until you're granted power, because if that doesn't happen, it's just going to be a continuation of what's been going on for years.
Thank you for that general public comment. Next time I'll hold you to talking about the actual case in hand. Is there any more public comment on this particular case? Hearing none, public comment is closed. I'd like to continue this to the call of the chair.
I would actually like to.
Member David?
I would actually like to make a motion.
Okay, very good.
So, as someone who voted no, against this every time, I do agree that it's time to send this back to ethics. That there's nothing to re-litigate here. I feel like that the Rec and Park Department was correctly named. The head of the Rec and Park Department is Mr. Ginsburg, and I don't see any reason. I mean, I personally don't think that there was a violation, but we're not re-adjudicating this. We sent it to ethics. They sent it back to us. I think we should send it right back to them saying we believe that everyone was correctly named, and then let ethics deal with it the way that they want to. So I'm making a motion to return this complaint to ethics.
Just on that note,
yes.
I think that's what Member Pilpel's draft is doing. Am I misunderstanding that?
It does. Please, no yelling out from the audience, please.
So, does your motion include this response, or do you have another response?
Well, I guess what I'm confused about is that the draft that I saw, I thought it's from Member Washburn.
Oh, I'm sorry. I created a draft for Member Washburn to sign. I wrote it, not Member Washburn.
You know what?
Mr. Burnett, we'll get to the heart of this. Now, and this draft was included in the packet, is that
Yes,
correct?
it was.
Okay, this is in the packet that you're reading here, page 140.
So I guess my question is, here's my question, is that if we, what is kind of the date, kind of roughly, like that this draft will be done and we would be able to send it back to ethics? Like kind of time frame. Yeah. If we don't do it today, when would it be? When roughly?
Let me just answer that. So partly I'd like to have Member Washburn chime in on this, and partly there are some procedural issues that we're discussing back and forth with ethics. Might it be prudent to wait for that to flesh out at least until November 24th meeting, and then bring this up by the next full task force, and then send it back? That was my original thought, but. Then again, this has been going on for some time, and maybe it deserves to get sent back now. So it's an interesting position. But I believe Member Pilpel's draft, which is in the package, is leaning towards sending it back to them. Correct?
Yeah. I just do not want this re-adjudicated again. That's I'm like, and I want it sent back to ethics.
I think the question is, they're asking for additional facts. Mm-hmm. We're restating what happened. We have no additional facts. We're going to send it back. I believe that's the direction that this body is going. The question is, do we take a vote on that tonight, which we absolutely can, or we can continue it, and at the next full meeting, the first week of December, try that motion again. That's kind of where we are.
Yeah, I'd be curious to hear what other members of if any other members of the task force have an opinion on this. Yeah.
So
then I'm going to make a motion,
okay,
and we'll see what happens with that motion. How about that?
Okay.
So I'm going to make a motion to send this back to the Ethics Commission tonight.
Okay.
Okay. Refer to the Ethics tonight.
Is there a second?
Second.
On the motion to
wait. Hold on one second. Let me ask a question. Let's say the motion, we take the votes. Let's say the motion doesn't pass. Does that conclude it? Because I want to
potentially.
I want to keep this alive so that when we have a fuller.
if the motion does fail, another member can make a motion to continue.
I see. Okay. what I thought. All right, very good.
I'm debating whether to make a motion to continue, because that would have precedence, and we would vote on that first.
Well,
What's your...
So through the chair, I just DCA Cola, can you just, so if we take a vote to send this to ethics and that motion fails, can another member make a motion to continue it to a future date and the file remains alive?
That's my understanding, yes.
So, yeah. Or we could go the other way. I mean, I don't want to vote no on re-referring it. I'm not 100% happy with the language here, and based on the discussion tonight, I think there's some things that need to get fixed here, and I really would like to hear from Chair Washburn. I mean, I think in particular, something further on who was the proper named person, because that was one of the issues. And the thing about the privacy balancing, I don't think I used that language.
I mean, I don't feel strongly about this. I just want to make sure that it's moving along.
It is.
I'm not.
Okay.
Yeah. I'm not.
I think if we continue to call the chair with the understanding that goes on next month's agenda, I think
We can continue to a date specific.
Yeah, to December.
The first Wednesday December meeting is,
Second or third?
Third, I think.
I believe it is December the 3rd.
I mean, I'd like to get rid of this as much as anything.
Okay.
You know?
Well, I'm willing to withdraw my motion. The second's willing to withdraw.
Yeah, do I withdraw first? Or will I just,
I think he withdraws.
do I just nod?
Do you want to move to continue?
So I'd like to make a motion to continue to date certain the next regularly scheduled meeting of the
December 3rd.
December 3rd.
I'll have a second for that.
Okay.
And I will do some more work on this.
That's fine. Yeah.
Not much more, but a little more.
The motion is continue the matter to December the 3rd. On that motion, Member Rummold.
Aye.
Rummold, aye. Member Winston.
Aye.
Winston, aye. Member Pilpil.
Aye.
Pilpil, aye. Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. The motion passes. Next on the agenda is item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction but not on today's agenda.
Mr. Bonnet-Shaw?
Thank you. Patrick Bonnet-Shaw, here on my own time as a private citizen. I have 2 announcements for you. One is that I don't believe the Grossman case is quite dead. I'm forgetting the particular paragraph number. 67 point, whatever the number is, 3B. The case of the underlying citation on his lawsuit. He has appealed to the Supreme Court. The city has filed the last of its paperwork, and so it's Mr. Grossman's lawyers. I think we're about 30 days out from hearing whether the Supreme Court will take up that case, and I hope that they do. The second announcement is, unfortunately, the Ethics Commission dismissed my complaint against Member Pilpel. And now I'm trying to decide whether to file a Superior Court case about it. Because they did not get to the merits of it. They waltzed into a closed session the other night with an improper agenda that did not announce that they were holding a probable cause hearing behind closed doors. They allowed Mr. Pilpel to hang out inside that closed room for 30 minutes. They tossed him out, and they met for another 45 minutes behind closed doors. When they came out, they took a vote and decided not to announce anything about what went on in that meeting. 2 days later, Mr. St. Croix issued an interested persons notice that did not even mention that they had gone into closed session to hear the complaint against David Pilpel. The day after that, I got a letter emblazoned with confidential on the front of the envelope, the back of the envelope, stamped on the letter, which had a watermark, confidential. And I ignored all of it because I didn't sign any confidentiality agreement with them. They can't tell me what I can choose to share with the public and what I can't, absent a confidentiality statement. And I was shocked that Mr. St. Croix said in the body of his letter that the reason the Ethics Commission dismissed the case was because the ethics staff had made procedural errors bringing it to the commission. I'm going, how incompetent can that staff and that commission be that they don't even know their own regulations and procedures for bringing a case to the commission? So now, instead of just dismissing Sunshine Task Force referrals for enforcement, they are dismissing ethics complaints because they didn't follow their own rules internally. This is the most dysfunctional body in city government.
Thank you. Mr. Piccirillo.
Thank you, Thomas Piccirillo. First, I want to thank the 7 of you for being here tonight. But once again, I'm more concerned about the 4 that aren't here, particularly your new appointee. It's my understanding that the last 2 meetings, he or she, seat 4, has not been here. And I don't believe seat 4 has ever been here. So I'm troubled by that. And I think the chair or the vice chair needs to have a conversation with seat 4. He or she signed up for it and hasn't been here. So I'm bothered by that. And again, I'm bothered by your attendance. It's important that you all show up. And now that you're not going to have special meetings, I guess maybe more of you will show up. I wouldn't want to think that it's because of some of the items on your agenda tonight. Some of the members didn't show up. And I do apologize for you having to take some of the abuse you took tonight, but perhaps you'll take that into consideration when you hear all your items on your agenda. Thank you.
Thank you.
Well, unfortunately, this is general public comment, so I'm going to go ahead and make it. After years of coming here, and seeing the dysfunctionality at the Ministry of Sunshine, because that's exactly what it is, the Ministry of Sunshine. I've said before, and I'll say it again, you people need to step down till you have some power. Without power, the Ethics Commission is walking all over you, isn't doing what's proper. You're being made to look like, people who can't get anything done properly. When you admit that you have no due process, this is pretty much, a democracy that has no foundation. For people who are seeking, what their legal rights are, the very first rule is to gather paperwork and to gather evidence so that you can prove your case and everything else. The purpose of Sunshine is to be able to do that in a timely fashion. When a person such as myself continually submits IDRs, let's say to the Department of Public Health, which continually violates them, and if they're by any chance found guilty of it and sent to ethics, nothing is done to them, so they do it again and again, because that will happen again tonight. It really answers the question as to why this place is so empty. People have learned that, this is a farce. This is unacceptable. This place is empty, for Sunshine. There are 1, 2, 3, 4, 5, 6, 7 people here other than myself. And these are major cases. This is about how, ethics deals with you all. No one's here to listen. No one's here at all because they've learned the game. They've learned how rigged this entire thing is. So, have some principle. Don't be the people that are used as shills for the city. Stand up for sunshine, for the truth. Not for, legalese or misinterpretation by the city attorney or, exclusions as to what, the law might specifically state. This has been going on for years, over 10 years now, in my particular case. Will it go on for another 10 years? Will I continue to get up and do the right thing? I think you guys know me a little better than that. The answer is yes. Will you guys do the right thing? I'm still waiting.
Is there any additional public comment? There being no additional public comment is closed. Next on the agenda?
Mr. Chair?
Yeah.
Could I just suggest that we take items 7 and 8 and then take a break?
I was going to consider a break at this point.
Oh.
Member Hines, what would your preference be? Good for a little bit longer?
Yeah,
Yeah?
I'm good.
Okay.
Yep.
First?
Great.
Good. Okay.
Thanks for checking in.
No problems.
Okay, item number 7, file number 14080. Update peace officer confidentiality, review and analysis of policies concerning peace officer hearings and the balance between the public's right to know what peace officers confidentially required by statute. Item number 8, file number 13091, complaint filed by Frank Lee against Jennifer Johnston, Civil Service Commission for allegedly violating Administrative Code Section 67.50 and 67.9 by holding complainants appeals hearing regarding claims of retaliation, discrimination against fellow law enforcement officers during a closed session of April 1st, 2013 Civil Service Commission meeting. Just a note on item number 8, I believe at the last meeting on this item, no violation was found at that time, and it was continued pending the provision of additional information.
Okay. Member Rummold, I understand you had a hand in this. Would you like to maybe give us a quick summary for the members?
In terms of where it is, my understanding of where it is, we had a hearing. After that hearing, we took the matter under submission because it was complicated. I drafted this draft opinion that, in my view, found that the CSC did not violate the Sunshine Ordinance by deciding to hold the hearing in closed session. However, I was of the opinion that the CSC's guidelines or their procedures for figuring out when a session should go into closed session and what the factors or considerations they should take into account, I didn't find those to be particularly powerful. So I suggested that they should re-examine those.
Can you just repeat the last line?
Suggested they should re-examine them.
Thank you.
And I'd like to be clear, this is, I think now, like the third time they've been back filing oppositions or whatever about this. And, I meant it more as a, perhaps there's more you can do than, continually relitigating it over and over and over. So there's that. And then I did note that the Police Officers Association filed some type of opposition to a statement in the opinion that people cannot be prohibited from disclosing the names of peace officers against whom they've lodged complaints, which I wholly stand by. I know DCA Cola and I perhaps maybe didn't see eye to eye on it, and apparently the The Police Officers Association does not either, but. So that is where things stand as far as I know.
Okay. And this speaks to the next case that we're going to hear. So thank you for that review. Any other members have any? Member Pilpel?
I assume in short order we're going to dispose of item 8 one way or the other. As to item 7, the 6-page write-up from Member Rumold, was it your sense that this is just for our review and digestion? Is there a need to adopt this or take some action on it?
No,
or what? Or is it just your analysis?
Yeah, it's my analysis. I mean, I think it could be adopted, but do I think it absolutely needs to be? No.
Okay. So I guess then I appreciate that. My larger statement on this that applies to both of these cases is as follows. I recognize state law 837, 832.7, and 832.8, how that relates to the Brown Act and Public Records Act and how that then informs Sunshine. I just want to state very clearly, I don't like 832.7 and 832.8. I think it is too broad. I think it confers more rights on peace officers than on other public employees, and I don't think that it is well balanced and serves the public interest. Notwithstanding that, I'm not in the legislature, so I don't get to, change that right now. But I just want to be very clear that under a matter like this, if brought against another city employee who is not a peace officer, would have been held in open session, and all of the facts and arguments and evidence related to that conduct, good or bad, would have been public. In this case, because it was a peace officer, that 832.7, 832.8 apparently controls. And I just don't like that element of state law. And I just wanted to make that known. Thanks.
Okay. Is there any comment from the public on this item?
Yes, I actually do have comment on this item. It's interestingly enough that I, for example, have several things filed against police officers with OCC. And you guys were talking about how state law preempts all this. I was given, when I went to OCC, I believe it was Penal Code 3300, which has to do with an investigation. The chilling effect that this is having, and I'm for once in agreement with David Pippel, is that, they won't even take my complaint against the officer. Well, if, everything's going to be holding closed session now, because of these state laws, the chilling effect that it's having is that they're so embrazen that now they're not even taking complaints. When I go in to make a complaint against a police officer for the OCC, I can't go in there and give my complaint and videotape me giving my complaint because I'm told that, 3300, which has to do with the investigation, just allows it. Well, the investigation isn't started until after I give my complaint, but I'm not even allowed that in OCC. That is, on YouTube also, just to show you how everything is interlaced to fail. This is the whole point. Any other agency, you probably wouldn't have this problem. However, because the policemen are heroes, which, supposedly is the way this country has been brought up to think, which is, of course, totally wrong because they work for us, they should be held to a higher standard. And that higher standard should be, that no matter what is thrown at them, even in public, whether they've had prior violations or whatnot, should be, heard openly because they work for us. But to not allow that then creates other problems. For example, the problem that I'm having just trying to file with the OCC where I'm not even allowed to do that and videotape the filing of it. I just want you guys to understand the gravity of this. And we've already had so many police officers found guilty of so many crimes. As a matter of fact, recently there's police officers right now that have new charges pressed up against them for the violations they did in single occupancy, stealing from single occupancy residents. So the police are not above anything. They're just normal human beings who put on their pants one leg at a time. However, because of this notion that that they're our heroes and everything else, these allowances should not be made, because, like I said, it then creates other incentive for them to continue to do illegal things. For example, in my case, not being able to file a complaint with OCC, and videotape me filing that complaint against an officer. Those videos are on YouTube, just to show how interconnected it all is to fail.
Thank you. Is there any other public comment on this item?
This is Sandra Ng from the Civil Service Commission.
Hello.
We would just like to...
I think because you're named in the item, you can't offer public comment.
I believe she can speak on item 7 concerning the police office confidentiality.
Fair enough, yes. Okay.
This is regarding the draft opinion. We do agree with the opinion's conclusion that the records generated and considered by the Civil Service Commission in its review of Frank Lee's discrimination and retaliation complaints against other police officers are exempt from disclosure under Penal Code Section 832.7, and that the Commission did not violate the Sunshine Ordinance when it held closed session hearings on those appeals. We would like to clarify a few of the items, and also to help with any future hearings that the Sunshine Ordinance Task Force may hear. We do want to clarify that the Civil Service Commission did not receive any public records requests directly from Mr. Frank Lee, and also in the opinion, it was through the Sunshine Ordinance Task Force that Mr. Lee made this request. Also, he did not implicate just 2 officers. There were actually a number of police officers involved. The Civil Service Commission does not take the position that the law requires blanket secrecy in its consideration of any complaint against a police officer. When the Commission receives a waiver of confidentiality from one of a number of peace officers, we actually look at this on a case-by-case situation to see if it is possible to conduct an open or partially open session. Our executive officer will actually review the staff reports, the investigations, the materials submitted by the appellant to see if it is possible with redactions. Again, because this has to do with a number of peace officers, we would also need to redact location, the station names, cases, and so forth. And we found that it would be very difficult to do so and to also still protect the identity of these peace officers. And in conclusion, the Civil Service Commission is committed to transparency and seeks to promote openness in its proceedings to the extent reasonably possible in compliance with the law. Thank you.
Thank you. Is there any other public comment on item 7? Seeing none, public comment is closed. Take number 8.
I did call both items at the same time.
Oh, okay.
Yes.
So on item 7, we're taking no action and just moving on to item 8? Is that correct?
Yeah.
Action, matter concluded.
Okay.
There being no motions, item number 7 is concluded, and I believe that there being no motions concerning item number 8.
No.
Hold on.
We haven't done that yet.
We haven't done that yet. I missed that we took them together, so I'd like to discuss 8 at further length. Is there anyone to speak on? Well, Mr. Lee is not here, correct? Is anyone
Mr. Lee in the room? There is no response.
Is there anyone to speak on his behalf? Okay. Discussion, members?
So, Member Rumwald, if we're likely not finding a violation, we could still send a letter or express our views or adopt some version of what you had. I'm open to things. Perhaps we could have some discussion on whether or not their procedures, the one-page procedures document, is robust enough. You were suggesting that it was not. Civil Service is saying that they are, and that they further document the number of cases in their year-end report. We haven't seen the year-end report. I don't know how they do it. I don't know. I mean, we could do something further on this.
Yeah. So to address the representative of the Civil Service Commission, I certainly appreciate that there are procedures in place for, peace officer hearings, but I went and looked at them again, and I still, it seems, and perhaps it is that in practice these procedures are more robust than they are on paper. But on paper, it is the executive officer will determine whether redaction of documents would be sufficient to protect confidentiality. If so, the commission will hold the proceeding in open session, and if not, it's in closed session, right? And so the process that goes into figuring out whether or not redaction is sufficient is completely opaque in the procedures. And that was the only point I was trying to make. And if in fact there is, some robust analysis of whether redaction will be sufficient, that's fantastic, and I appreciate that, and I think that helps to encourage transparency. But the fact is that on paper, as currently written, it doesn't appear that way. And so with that said, I mean, I could go either way about adopting what I wrote. Honestly, it might, because it raises the issue that the Police Officers Association apparently takes quite seriously about whether or not names should be included in this proceeding. It might be a more diplomatic approach just to not adopt it, have it continue as a draft, but whether or not I will just say I don't know.
If I may, first of all, thank you for taking the time out to conduct this analysis. In my work, I've dealt with these issues quite extensively, and they're really alarming, especially when you look at California's statutes compared to other states in the country regarding peace officer confidentiality or police officer confidentiality. They don't use that term in other states, and I think it's actually quite serious. We've seen that in the Long Beach decision regarding the names of officers involved in officer-involved shootings. Law enforcement unions will push back on the disclosure of any sort of information about individual officers through public proceedings. The civil court is literally the only way you can find a seam in that wall. And quite frankly, I think it would behoove this body to make a stand on that, and maybe look at finding a way to look at adopting your report into a little bit more, look at codifying or making a statement about it, because quite frankly, in what I've seen about Mr. Lee's case, there does appear to be ways to have this hearing in public and replace the officers' names with X, Y, Z, maybe redact the station name, put station A, B, C, D, or E, or F, and give him and the public a little bit of insight into this process. And I'm actually curious, since 2006, when was the last time the Civil Service Commission held an open hearing on an incident involving a peace officer? Since the Copley decision.
The appeals regarding peace officers in terms of discrimination complaints, future employment restrictions, were actually on hold until procedures were written out and the guidelines were set up before we proceeded with hearing these appeals. Appeals regarding peace officer examinations and so forth is quite different because it does not involve the actions or the performance of peace officers.
Mm-hmm. But regarding with such a complaint of one peace officer against another, right, involving matters that would be considered confidentiality, after the Copley decision came out, Copley Press, right, third-party agencies cannot disclose such information. Has the CSE held an open hearing regarding that sort of matter?
We have not been able to.
Because of the Copley Press decision. That's the controlling case for your office, or is there another matter that covers that?
It's actually because it's on a case-by-case. The Copley decision does play a factor, but we do review each case separately. It is not automatic just because if it's a peace officer appeal, it's held in closed session. It is looked at on a case-by-case situation.
But since 2006, there have been no open hearings about peace officer matters.
Right.
Okay, that's a problem. Member Rumble?
Go ahead.
I was just going to follow up on that particular point. Do you recall how many closed hearings have been held? You're saying there were no open
off
hearings.
the top of my head, no, I cannot tell you the total number.
Okay, but it would only be in 2012, 2013, or 2014 because those things were all held until this policy was adopted. So perhaps if you could look at the annual, or what do you call it, the year-end reports, those would capture those numbers?
Yes, it would capture those numbers, and we actually, that is posted on our website once we provide that report to the commission. It's normally in August, and we've recently started posting that information. We can also provide that to the task force.
I don't know that the task force needs it right this moment, but I'm thinking about this one page of guidelines. I know a little bit about how this came about. This was not, a simple 5-minute exercise. It actually took a long time to develop. But regardless, I think Member Rummold makes a great point that the executive officer exercising his or her powers and figuring out how things are to be handled, that all, what was your term, opaque? Right? It is somewhat opaque, and although your annual or year-end report may capture the numbers after the fact, there's no real, what's a good word, contemporaneous memorialization of how this process played out. And I'm thinking off the top of my head, maybe if an agenda item that is to be heard in closed session had some kind of statement either on the agenda itself or in an attachment that said the executive officer reviewed the matter and determined that this could not be held in open session or could be held in a partially closed session pursuant to the guidelines, right? That there would be some explication at a relevant time as to what happened, even if it's captured later on as well. Member Rummel, does that make sense? And Ms. Ng, if you want to comment on that after Member Rummel.
Yeah, and I would just add that another consideration is to include in any type of process-y type disclosure is the factors that the executive officer considered in making his or her determination that redaction was not sufficient. Right, that's the real problem that I have. Is just, we don't know if they picked up the paper, said, oh, they didn't waive, so redaction's not sufficient, or if there's actually some type of analysis that's involved.
Ms. Hay?
We do not have that on the agenda. However, before the commission does go into closed session, there is a brief discussion because the commissioners actually have to agree to take the matter into closed session, and public comment is available before they go into closed session. In this situation with Mr. Lee, because he waived confidentiality, he had opportunity to speak, keeping in mind that certain information he could not be specific about. So the commissioners did have a chance, and the public did have a chance to hear briefly as to what the matter may be considered. But this happens each time there is any matter that we're about to go into closed session, that the commission does have to vote on this, so the public does have an opportunity to speak up and share their concerns.
Member David?
Yeah, to move things along, what I would suggest is that Member Rummel, I would like to consider, there doesn't seem to be violations here, which is what I think we've said, but perhaps an advisory letter, just kind of like, here are our thoughts. We would like you to take it into consideration, a couple of suggestions, and then, you guys take it to suggest, do with it as you see fit. But I think that, I think Member Rummel makes some outstanding suggestions, and I would hope that the commission would, take it into consideration and maybe, look at their procedures and maybe adopt a couple of them. And so with that being said, I'm wondering if that would be okay for us to make a motion to have Member Rummel provide an advisory memo, share it with the task force, and then upon the task force approval, have it sent over to Ms. Lee.
Yeah, and if Member Winston would like to chime in on any of that with Member Rummel, that would be welcome. Yeah. Should we take some public comment on this?
Did we need a second on that? I'll second.
Okay. All right. Thank you, Ms. Ng. Is there any public comment on this item, item 8? Seeing none, public comments closed. Member Philpell?
So let me understand, it's a motion to find no violation and to ask Member Rummel to prepare an advisory opinion letter for the task force to further consider, so it doesn't completely, the file will still be open until we...
No. So I think we're close. We never have to make a motion to find a no violation, right? Okay. So there is
but implicitly, there's no violation.
Right. So what it is that there's I don't know if it's a motion is the correct thing to make, but at the end of the day, what I would like to see accomplished as an action is of Member Rummel writing a friendly advisory letter, like, here are our thoughts as the task force onto how you could potentially improve your procedures. That's what I'm looking for. So I don't know if that needs to be done by motion or...
Yeah.
Just to be clear, what was the action, if any, the last time we heard this case? Was there an action or was it just continued?
The matter was continued, but I believe there was intent to find no violation.
Okay. All right. I just want to make sure that we're being consistent with this. All right. Okay. So.
I believe the motion is there being no motion regarding the complaint itself, that matter would be concluded, and that a motion separate from this complaint.
The action.
From this action.
Yeah.
Is to request that Member Rummel prepare an advisory letter that will be presented to the task force at the next meeting for approval, and if the task force approves that advisory letter, it will be submitted to the Civil Service Commission.
That is my intended motion, yes. So.
Second. Okay. Very good.
On that motion, Member Rummel.
Aye.
Rummel, aye. Member Winston.
Aye.
Winston, aye. Member Pilpil.
Aye.
Pilpil, aye. Member Hepner.
Pass for now.
Member David.
Aye.
David, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Member Hepner.
Aye.
Hepner, aye. The motion passes.
Yeah, I think that'd be a good idea. I think we'd like to take a 15-minute break at this point.
The task force is in recess.
Till 6:30, let's say.
Is in recess until 6:30.
Yeah.
Don't know where this from. She's like, there was no guns at school.
All right. I'd like to call back.
Out.
I'd like to re-adjourn the meeting.
Yes, item number 9, file number 14048, complaint filed by Cecilia Hairston Omonde against Donald Ellison and the San Francisco Municipal Transportation Agency for violating Administrative Code Section 67.21B, 67.21E, and 67.29-7 for failure to comply with requests for public records and failure to provide a knowledgeable representative to respond to question. The task force referred this item to the Complaints Committee. The Complaints Committee heard it at their last meeting and referred it to the task force. I believe if Member Hepner wanted to give a summary of the issue.
That'd be great. Thank you.
So the reason this is back before us today is because it came before the Compliance and Amendment Committee and respondent did not send, had not fulfilled their compliance. We had ordered, I believe, 3 things done in our order of determination on September 4th. They had not been done by October 21st, which was the date of the Compliance and Amendments hearing. The representative, I believe it was Mr. Carlos from the SFMTA, appeared and indicated that he had no knowledge why compliance had not been met, no knowledge of why no one had attempted to make any compliance, no knowledge as to why the respondents were not present to provide an explanation of why compliance had been met. So I was essentially left with no choice but to refer this matter to a next meeting, and with that representative's sort of promise that he would address this in full by the next day. So that's how it came back here, and I advised that representative of the SFMTA to be thorough and keep in mind that he's convincing us not to find any further violation of the Sunshine Ordinance or our order of determination. So I think it would be prudent to bring up a representative of the SFMTA if a representative of the SFMTA is here.
Can I make a statement?
I don't mean to usurp.
No, that's fine. Okay. So basically, we're here to hear what they're going to do to redress the situation.
Yeah, I think that this would be a good time to sort of address this as a continuance of the Compliance and Amendments hearing on this matter. Okay. The idea is to get to the bottom of why no explanation was made and no attempt to comply with our order of determination was made.
Okay, typically we hear from the complainant first, but I think in this case, maybe we can reverse that and have the respondent answer that very question. So, Member Pilpel.
Yeah, I just want to make a statement on the record. I was not present for this hearing, but I did review the documents in the packet. I did not get a chance to listen to the prior audio, but I think we had a related case from the same complainant before, so I'm familiar with a lot of the underlying facts and all. And furthermore, I should state on the record that although I know many, if not most, of the players at MTA over the years, it was fun going back through all these appointment processing and separation reports, that I don't feel that I have any bias in the matter and that I can hear the matter.
Thank you, Member Pilpel.
Thank you.
So if you'd like to give us a background, just pick up from where Chair Hepner.
Right, and just to narrow that question, first identify yourself on the record, and then I would welcome an explanation as to why nobody was sent to the Compliance and Amendments hearing with any knowledge of the order of determination or why compliance had not been made.
So, my name is Kathy Fowlis, custodian of records for SFMTA. I was unable to attend, and they did send a representative, I believe. It was too late for us to pull it from the original agenda, but I had bronchitis. So that's why I couldn't make it.
Okay. I'm going to remain calm here because this was rather annoying and a bit egregious. There was no notification from you, no notification from Mr. Ellison that you would not be appearing at the Compliance and Amendments hearing. Excuse me.
Given. to the department that they knew I was out ill due to bronchitis.
Okay. No notification was provided to the task force as to why any respondent named in the complaint was not
Why
made.
no one notified
Mr.
you,
Clerk?
but I was ill, so.
Just 1 second, Mr. Clerk.
Mr. Chairman, the office was notified that Mr. Ellison and Ms. Fallis were ill that day, the day before the meeting. They did send someone from the office to the meeting, but I don't believe he was completely knowledgeable of the issue. After that meeting, we did receive additional documents from the SFMT of approximately 100 pages, which is in the packet.
Okay.
Can you indicate what new material?
Hold on. Let me run this. Member Hepner, was that material pertinent to these 4 areas?
The October 29th communication that was given to us, or I assume forwarded to Victor following the compliance and amendments hearing. So I don't know that it fully addressed Ms. Hairston-Omondi's concerns, and that's something that we can look into. I don't know that she received it. But one question that I would like to have answered then is, why was compliance not attempted prior to the compliance and amendments hearing?
Because we had provided Ms. Harrison-Omondi the records previously.
Okay, that's a violation of our order of determination, in which we found 2 violations. 1, that you had not provided full public records, and 2, that you had not sent a knowledgeable representative, and I believe that was yourself, to the task force to confirm that full compliance had been made with the Sunshine Ordinance requests. So you're looking at me very skeptically, and it's really angering me.
I'm starting to get a little confused. The hearing that I came to was not addressed for me. That was actually for my director, Mr. Don Ellison. So I was called in last minute just to come in his place.
Right. So at that time, you had very little knowledge, or not sufficient knowledge to. Excuse me. It's not going to help if we're talking over each other. It's not going to help if we're talking over each other.
Okay, go ahead.
You were sent to this hearing last minute with very little knowledge of the complaint or the underlying matter. So we found a violation that the SFMTA had failed to send a knowledgeable representative. That's 67.21 subsection E. All right. We also found a violation of the Sunshine Ordinance based on failure to provide full responses to Ms. Hairston-Omondi's public records requests. Now, that violation may partially have been based on the fact that you could not testify to whether public records had been adequately provided to Ms. Hairston-Omondi. In any event, we referred this to compliance and amendments and issued an order of determination that said you have to do these 1, 2, 3 things, and those 3 things were not done prior to the compliance and amendments hearing. So we had Ms. Hairston-Omondi here, and she brought 2 representatives to testify on her behalf, and you sent, the SFMTA rather, sent a representative who had no knowledge of the complaint whatsoever, no knowledge of the underlying matter, had no explanation as to why Ms. Boomer was not present, and no explanation as to why compliance had not been met prior to our meeting. Now, if it's your contention that compliance had been met and that all public records had been sent, we needed that communication prior to the compliance amendments hearing. Without that, I was left with no means of finding that compliance had been made. You understand the predicament that put the Compliance Amendments Committee in?
My understanding, those documents was already provided to Ms. Harrison-Omondi as of May 9th.
Okay, that information, that verification was not provided to us in a sufficient manner either at the September hearing before the full task force or at the Compliance and Amendments Committee hearing.
You need to copy us on that, is what he's saying. Were we ever copied on those documents?
No, because I probably wasn't even involved for those hearings.
Member Hepner, is there someone else that...
Was my name there? I mean, if anytime I've had to come here, I've come here besides the time when I was ill. So the last time I came here, there was nothing mentioned that I had to attend. I was called in last minute because Mr. Ellison was not able to attend.
Okay, and was Mr. Ellison not able to attend this evening?
Mr. Ellison is right here.
I think we should talk to Mr. Ellison.
Okay.
Good evening. My name is Don Ellison, Director of HR for SFMTA.
And if you'd like to address why compliance was not made prior to October 21st and why we were left with no option but to refer this back to the full task force.
Okay, my understanding that it had been done, so I was not aware that the compliance was not done. There was a directive. I looked at the documents. I believe that I signed them. I apologize if they did not make it here.
Do you have a copy of those with you today?
You have the earlier documents? Which I believe we sent the same documents multiple times, and you're getting the same documents that we sent the previous commission hearings.
Have you seen the order of determination in this matter that was issued on September 4th?
So that order of determination is asking for additional documents. Have you sent us anything additional since September?
Our position that there is no additional documents, there is no additional relevant documents. My understanding is Ms. Omandi is saying there's documents available, and our position is that there has not, that we have produced all documents that were available, documents that she's seen multiple times and that we have presented to this commission.
Okay, I understand that. Now, Mr. Ellison, the order of determination in this matter requested a summary of the response to each request made by Ms. Hairston Omandi. That summary shall include, 1, a statement as to how each of the requests or questions were addressed and what documents were provided. 2, a statement as to why a document, if any, was withheld. And 3, a statement as to what documents do not exist. That is the summary that we needed on October 21st. And no one appeared, and that statement was never provided to us, and more importantly, was not provided to Ms. Hairston Omandi.
I don't
That
even.
might have been Caroline's letter.
Okay. But
Can't turn it down. Pink. You're seeing a lot of pink? I don't see it. You need to be chairman. That's how you turn it down. Better see as well. Victor's bucket. Mr. Clerk, can you give them the first page from the packet, and just show them those 3 items, just so they have it in writing? I'm sure they have it.
Thank you.
That might help.
Oh.
Okay. Good idea. If you two could just step aside for a second,
sure.
we'll
Okay.
give you a good moment to gather your thoughts. Ms. Amandi, would you like to approach? And Mr. Hepner, do you have any questions for Ms. Amandi?
Yes, we have a letter dated October 29th in our packet, and I'm wondering if you received that letter, and if so, when, and if not.
I haven't received anything from Chrissy Board. He said he was going to send something. I haven't received anything.
Can I follow up on that? So, Ms. Hairston Omandi?
Yes.
Hello?
Yes.
Page 283 of the packet, this October 29th letter
What package?
of our packet.
This is tonight's package we're referring to.
This was supposedly sent to you via regular and certified mail last week. Did you, by chance, receive that at your humble abode?
What am I supposed to be receiving?
This letter. Have you seen this?
This?
Yes.
Yeah.
Did you
No.
get that from MTA?
No.
No.
It's addressed to you, and it's certified mail receipt, October 29th, so you probably would have got it the 30th.
I haven't
Thursday.
received nothing yet.
Okay.
Okay. So maybe we'll follow up with MTA as to whether they got a return receipt.
Do you want me to keep this?
Give it back to the clerk. And Member Hepner, this is not what you're looking for. This is part of the original.
Well, I'm assuming that this was their attempt to satisfy the order of determination, but it's clear that they weren't looking at the very specific information requested in the order of determination, because does not address those 3 points.
Okay. Member David?
Can I direct a question to Member Hepner?
Sure.
So I'm just, Member Hepner, do you feel that this was an oversight, or do you feel like there's something deeper here, like that this was willful, or was this just? Do you think? Are you
just
communicate?
Judging by the presentation of the SFMTA representatives present, I think it's more likely an egregious oversight. I don't know that the SFMTA understands what we do or what they have to do when they receive a sunshine ordinance request. I mean, this is just. It boggles my mind that they did not. I mean, he promised me emphatically that he was going to address the order of determination the next day.
Can I just say who's he?
Mr. Carlos, the gentleman who was...
Chris Ibarra.
Was that Chris Ibarra?
Yes.
Okay.
Right, and he promised emphatically that he was going to address the 3 items in the order of determination. He would talk to Mr. Ellison and get to the bottom of this by the next day.
So it seems to me, I mean, maybe I'm wrong, but it seems to me pretty clear that the order of determination has not been addressed.
I don't believe
not
so.
To date.
I don't believe so.
So I guess to me that leaves us with a couple of choices, right? And that one, do we set when I don't know when the next compliance meeting is, when the next do we say like, look, we'll err on the side of like this was an egregious oversight. You have another bite at the apple. Like get this right, or do we say this is a willful violation and we send it to ethics?
I'd agree. Those are the 2 options.
Yes, and so.
And despite how your day went today, setting that aside, what do you feel would be an appropriate next step?
I'm somewhat appeased by Mr. Ellison's presence here today. I'll say that much.
Can I?
Okay. Thank you. Chris, hold on one second.
Okay. All right.
So, Mr. Ellison, as you can see, there's still more work to be done. And, I don't think you're going to be able to get it done there. Because there's 3 points here that are outside of any materials you might have. Victor gave you the 1 page with the 3 things that we're looking for, in addition to documents that you've already provided. And I'm guessing that's the first time you've seen that.
Yes.
Okay. So.
Okay.
My instinct is perhaps to, and Mr. Clerk, when is the next compliance and amendments meeting? Now that we're back to regular schedule, is it next month?
Yeah.
It's not. We're not skipping every other month anymore, are we? That's done.
They still continue to meet every other month.
Oh, they do.
We're going to talk about that later.
Okay. I'd like to get it seen sooner than every other month. I don't know if we can fit this in as part of maybe the complaints committee. Can we sneak that in as an agenda item? I mean, I'd just like to get this resolved sooner rather than later, rather than waiting 60 days, to get this.
May I ask a question?
Yeah.
Through the chair, may I ask a question, Mr. Ellison?
Yeah.
Mr. Ellison, do you now have the letter that asks the letter of determination that makes the very specific requests?
Yes.
Okay, so looking at that letter, what do you think is a reasonable time frame that that your department would be able to respond?
From your next hearing date. We're not going to be adding. We'll be adding explanation, but we won't be adding any additional documents.
Right, but there's a very clear, right? Three. Am I
yes.
correct,
Yes.
Member Hepner? 3 very specific asks. And so,
with the knowledgeable representative too.
yeah, with the knowledgeable representative, and then I would like to ask. I'm sorry, ma'am. I can't remember your name.
Harrison Amondi.
Would you please come to the microphone? Would you be satisfied if SFMTA fulfills the request that was made, the order of determination, by the next hearing of the Sunshine Ordinance Task Force? Would that be satisfactory to you, or not?
Well, they had plenty of time. They had plenty of time. So, I mean, the next meeting, it may be another problem.
Well, so let me say this, that I think from the task force point of view, if there's a problem the next time, there will be zero tolerance for that. That's my sense. But I can understand your frustration also if you're like, no, you know what? They had plenty of time, and I would not be satisfied waiting another 30 days. That's why I'm asking.
Well, I've been waiting since last year.
Understood. That's why. So would it be your preference that we find a violation?
Find a violation now, and also I need the documents.
I'm sorry?
We already found a
Yeah, no. I'm saying, right, we've already found the violation. I guess my question is that would you, the violation's been found, they have not complied with the letter that we've asked them to do so, right? So we have two choices, right? We can say that they have to fulfill the letter, right? So the question really is that do we offer a stronger punishment while they're fulfilling the letter, or do we give them 15, 25, 30 days to fulfill the letter, which it might take them that long anyway, regardless of whether we give them an additional punishment? So this is what I'm asking.
I'll accept the first one.
You would like us to find a willful violation, is what you're saying?
While I'm waiting. I mean, I've been waiting since the first time I came in here.
That is why I asked the question. Thank you.
Member Pilpel?
Yeah, a couple of things. And it would be great if Mr. Ellison and Ms. Fowlis could hear some of this. I want to agree in part and disagree in part with what Member Hepner said a few minutes ago. I actually think that the MTA has a pretty good system for responding to sunshine requests generally. I deal with Ms. Zelaya on a regular basis. I request things, I get things. I got something in the mail today. I do think, however, that the MTA does not do a good and consistent job in responding to either sunshine requests or requests from employees to review their employee file. And this has come up not just in this case, but in other cases. And so had I been at the prior meeting, I would have asked that MTA develop and we review their process for employees seeking public records related to their employment, because this has come up time and again. We've had discussions about waiver and what's a public record and whether an employee request should be treated as a sunshine request or treated per the MOU and per the labor code. And we just don't get good, consistent results from MTA in this area. I am tending to lean to find either a willful or a non-willful violation and refer it to ethics and name Mr. Ellison, but I'm open to other solutions. And, you know, I hesitate to say this, but if I've reviewed these documents correctly and if I understand some of the separate facts here, Ms. Hairston Omandi was involved in at least 2 fatal accidents while operating a Muni vehicle and continues to be employed by the city in a non-driving capacity, and it doesn't appear is going to be returned to a driving capacity. I think that there is some fundamental problem at MTA if that's how something like this is handled. I know that's beyond our purview, but as I went through the documents, that just absolutely yelled at me. And
thank you, Member.
And I don't know how to hold MTA accountable for those actions.
Member Hepner, since you have Mr. Ellison in front of you and he has those questions, would you like to take a stab at maybe verbally answering 1, 2, and 3, just to kind of feel it out so we get a sense of what we may expect down the road?
Okay, I'm going to ask Ms. Fowles to do this because I'm not close enough to this information. So, and I want to say...
Let me just read it for you first, just so you understand. I mean, it's on that page right there. In addition, it is requested that respondent, and you are named directly, Mr. Ellison, provide a summary of the response to each of the requests from the complainant. And you have that list. At the minimum, the summary shall include 1, a statement as to how each of the requests or questions were addressed and what documents were provided. 2, a statement as to why a document, if any, was withheld. And number 3, statement as to what documents do not exist.
It's clear.
Okay. So would you like to try and address any of those with your colleagues' help to Mr.
Jeff, you
Hepner?
want to talk about?
So is the questions 1, 2, and 3? Which ones?
So what we're looking for is a very detailed statement of all those lists of requests that Ms. Omandi had. And that's number 1, and how those were handled. 2.
So with question number 1, correct?
Yes.
Isn't that what we're speaking of?
Yeah, correct. Yeah.
The question and the records that Ms. Omandi was seeking was why and who authorized changes to her original arbitration decision of April 20, 2007, which is number 1. She wanted all these official documentations based on why was her original decision, she claims it was changed.
Okay.
So what we provided...
Rather than going through each and every one, what we're looking for in writing, and correct me if I'm wrong, Member Hepner, is how you responded to these
We provided Ms. Harrison Omundi.
12 points.
Yes.
Okay. Which ones you provided, which ones you didn't. And if you didn't provide, why?
Okay.
So this is a pretty detailed report we're looking for, and we issued this weeks ago. And I'm sensing rather than go through this incompletely now.
I think that they should take this seriously and take the time that it takes to go through each of the 12 items. I could write up the outline for you, 12 requests. Under each request, state what documents provided that were responsive to that request. State which documents you did not provide. State that no documents existed that were responsive to that request. But for each of the 12 requests, respond to each of those 3 orders of address each of those 3 sections of the orders of determination. That's what was requested of the SFMTA on September 4th and again on October 21st.
So for those 12 points, which ones you provided, which ones you could have provided but haven't yet, and hopefully will, and thirdly, which ones she's asking for that don't actually exist. That's it, in a nutshell.
Yes, and I believe those was answered back in...
So what you guys answered back then was the original response to the 12.
Correct.
What we're now asking is, okay,
We've given you the 12, but you want additional information on top of the information we've already provided.
exactly.
Am I correct?
So the 12, the information you provided, we weren't convinced at the previous hearings that that was all the information or that it was provided accurately. So we're saying, okay, there's probably more. Please list that, and as next step, provide it. If you feel there isn't more, list in each case against, number 5, number 6, that this does not exist.
And I understand that, and
Okay.
that's why I've met several times with Mrs. Harrison on Monday, since she clearly states in her letter of May 6th that every document she is seeking is in her official personnel file. I've met with her on 4 separate occasions. This way, it would help me to provide her with the actual documents she's truly seeking.
Great. Okay.
But-
So you have those 12 points,
Yes.
and you have 3.
And I did that
Answers
with
to
Ms.
each.
Harrison on Monday on 4 separate
Ms. Fowles, I'm going to stop you. Your indignance is not helping you right now.
I'm not trying to be, I'm trying to explain that I've sat with Ms. Harrison on Monday on 4 separate occasions. Every sunshine request or every request of records that Ms. Harrison on Monday provided me, I sat with her so I can provide her the actual documents that she needed.
So what we need this now in writing.
Okay, that's
So
fine.
basically, we just need
Again,
this.
okay.
We just need this in writing now.
Okay.
Right?
Thank you so much. I understand, but I just wanted to make it clear that, yes, I've done it over and
I understand that you felt that you've answered everything, but for the record, we need to get this down in writing with these 3 questions addressed to each of those 12 points. Mr. Ellison, you understand that, correct? And I strongly suggest you take a great interest in this going forward, because it's your name on the block, not your colleagues.
Well, no, and I've got that.
Okay.
Can I follow?
Member Hepner, and then Member Pilpel.
I believe that we should leave an opportunity for Ms. Hairston-Omandi to address this.
Okay. Would you like to add anything to that?
I think when we were here the last time, you had mentioned you didn't know whether you were going to imply Ed Reskin as part of having knowledge of this case, which he does have knowledge, and Don Ellison is aware of it.
Mm-hmm.
And
I'm sorry, who is Ed Reskin?
I guess he's the CEO or the manager
Of MTA?
of MTA.
Outgoing, isn't it? Or no?
Present.
Present, okay, sorry. I'm getting confused with the elections. The director, I think, is new, apparently. Okay.
Yeah. So,
All right. Member Hepner, do you have any knowledge of what she's referring to?
I don't recall that we were nearing adding Ed Reskin in this matter.
I think it was 2 meetings ago. You said you guys were kind of undecided, but if you found out that Ed Reskin didn't know anything about it, that he may be added to the charge.
And Mr. Ellison, what is Mr. Reskin's relationship to you? Is he your 1 up, 2 up?
Reports directly. He's
Okay.
a direct report to me.
Okay.
I mean, our orders of determination evidently don't reach 1 below Ed Reskin, so I'm not really sure.
But I haven't gotten any feedback as to what Ed Reskin is saying about my status on non-driving status for coming up on 8.5 years.
Unfortunately, that's not within our purview.
Understand, but
We're looking at strictly those 12 questions you have and the 3 follow-up questions for each that we've outlined for them. Your MTA status is not within our purview.
right, I understand that.
And if he was part of that original information request, which I don't think he was, however, if he falls as head of department, we could certainly name him in addition to Mr. Ellison if we so chose to do that.
Well, Mr. Ellis had a telephone, well, not a telephone, but he called me and told me that he's keeping Mr. Reskin informed as to what he's doing.
Okay, he may have been referring to your status versus this information request.
We're trying to find, status, yeah.
Okay, so the status is out of our ballpark. That's not our purview. Our purview is the information, getting you the information.
Okay, all right, with that case then being said, I had about 9 questions, and if he can make it easy for me so I don't be trying to run through the package or whatever he sends me chasing after something, if he can give me for each question a page for each.
And what are the 9 questions referring to?
That he has it, okay.
Oh, part of your original 12 are the 9? Is that what you say?
Yeah.
Can someone refer to page 401 of our packet? Is that the letter with the 9 points that's being referred to now?
Mr. Clerk, maybe you can look at what she has in front of her and see if that is.
And ask you what are the 12 that you were talking about?
Page 4. The original order of determination. It's below that.
This is the one that you had sent me. Oh, no, is this the one here?
Yeah,
No, that's not.
1 through 12.
Oh, okay.
Yeah.
Wait a minute.
Yes, it does look like page 401 is the rest of the stuff.
Okay, thank you. Give us a moment while we look at that. Okay, this looks like information request. To the attention of Donald Ellison, Manager of Human Resources. I, Cecilia B. Harrison Omondi. Is that the letter referring to?
Let me get my other paper.
Okay.
Page 401, is this correct?
401, yeah.
Nick? Look at page 311. I'm trying to find the rest of this document. 311.
This looks to me like information about I guess it is a sunshine. Member Hepner, does this fall within the 12 points of the order of determination? Can you see?
I'm just scrolling to.
Yeah, 401. 401 in the package. Yeah, it's way down the bottom, about 4/5 way down.
I believe that's the beginning of the request. It does look like it's not the complete request that made it into the complaint that came before the task force in September.
Okay.
But that first item,
I might be able to explain that. I believe there were two complaints made by this complainant. One, I believe, was
We merged it, right?
13043.
Right.
And then there's this one that's at issue. It was almost mirror image.
I think we joined it, right? I think
Yes.
we combined them. Yeah.
So I think it was almost a mirror image of the same request for information.
Okay.
So that may be
was 9
that page
questions.
311
I'm sorry, what was that, Ms. Amondi?
might be one that's
9
original.
questions.
Nine questions, right. But let me ask you this. If in the 12 questions that we're considering today, if we get the information that we're seeking as per our order of determination, what have you provided? What's still there to be provided? And what do you claim is not available? If we gather all that information, Mr. Ellison provides that information to you, will that satisfy your request for information at this point?
I don't know. I haven't seen the information yet.
Fair enough. But if they do their best to provide that, will that satisfy your original information request? In other words, if they provide everything they have, as they're now bound to by law, will that satisfy your complaint?
It's kind of hard to answer.
And you have to keep that separate from your status, because it's not about the status, it's just about the information.
But the information they won't provide, and that's the city attorney's letter that I have read myself, and he won't provide that.
Well, if they don't provide, they have to say why, and you can take all that information through other channels. But we're forcing them to provide what they have, and if they won't provide it, say why.
Mm-hmm.
So that should give you quite a lot of information to then take this case, take your case further, especially with regard to status or whatever you want to do with that information.
I don't want to answer that until I see the questions.
We need to see the answer.
Okay, that's fine. Fair enough. Ms. Member Bilbo.
I want to go back to my earlier point. I'm still not convinced that MTA has good procedures in place for dealing with employee requests, and I would like us to ensure that happens sometime. I mean, I was troubled a few minutes ago when I think Mr. Ellison said the order of determination he hadn't seen before tonight. Did I hear you correctly on that? Okay, you're listed as a CC on this document, and I assume that was distributed to you 2 months ago. Did it somehow miss you?
Commissioner.
I'm not trying to be hard. I
understand that, and all I can say is I didn't receive the document. The previous 2 hearings, I wasn't present, so I didn't hear the outcome of the commission. I wasn't here, so I did not see this document. So,
okay.
And procedurally, and I'll say this for what it's worth. Staff responds. It goes, as you know, to Caroline, collects the data here and stuff, and it's gathered for me. And so, and again, my assumption was the document was responded to. So, and I was mistaken.
All right. Well, maybe on our side, we need to ensure that all orders, if they're not directed at the department head, need to be copied to the department head. So, we can't say that they weren't in the loop. Certainly, Ms. Boomer received this. I assume she saw it.
No idea.
Right. And if you're going to have Ms. Fallis as your records person within HR, if Ms. Fallis isn't available, you probably need to have a backup person. And that's up to you to figure out who and training and all that. But
So the buck stops with you.
This suggests to me just frankly, a general failure at MTA HR to be able to deal with requests related to employee records from employees or from the public. And that's hugely troubling for an agency that that I know that is as important as it is with all the people, with all the issues. You got people on the streets all the time potentially doing stuff, and there's a lot of records going back a long time, and you've got a lot, not just at 1 South, but at all the divisions as well. And you've got ultimate responsibility for that. And so I want to ensure that you've got procedures in place, whether something says immediate disclosure request or 72 hours or whatever, that they're getting the right response and aren't getting a runaround about having to sign waivers that don't really apply because it's their own personnel file. And I'm just not satisfied that that's happening right now. So, somehow I would like to ensure that happens. Tell me how, and I'd like to add that.
Thank you, Member Pilpel.
Because otherwise we will be seeing these things again and again from MTA.
Agreed.
And we have.
Mr. Clerk, when is the next scheduled Compliance Amendments Committee meeting?
December 20-something.
I believe that'd be, I don't have an exact date, but it'd be early December.
Okay.
We could continue this to the next Sunshine Ordinance Task Force meeting, which would be December the 3rd.
If they can respond in 3 weeks and get it into the packet, we can do it next month.
Okay.
We want to keep the heat on you, right?
Yeah. Let me ask one question. Member Hepner, I definitely want you to be present, whether it's full task or compliance. Again, can you quickly check your calendar, and is there, any reason you won't be here on December 3rd, which is the next full task force?
I'll be here for that. I'd also be fine if it was kicked to compliance and amendments and was on December 16th and was a more comprehensive review of how orders of determination are handled by SFMTA, at which I would...
Yeah.
Including my thing about procedure.
Yeah.
Exactly.
Yeah. I really think that would be more productive use of the task force time. And I'm sorry you have to hear this again, but I think this is basically going to be your last chance to provide answers to all those 12 questions and give us some written policies as to how you're going to handle future sunshine requests within your department. Is that fair?
That's fair.
Okay.
December 16th, I think you also had the Paula stuff for arts.
That's fine.
All right, good.
Okay. All right. Members, I think that's probably the direction we're going to go. Any other discussion?
Through the chair, I just want to say, I think I just want to be clear that, or bring up the issue that I think that these things should be bifurcated maybe. Like, I want to make sure that this case is dealt with, and then I think there's a separate connected issue of making sure that they have policies in place. I don't want to, I want this case to be dealt with, and that we might want to do a separate EOTC
Well,
type of
I think in the interests of committee time and the fact that that's 5 weeks from now, I think that's, given the egregious nature of where they stand before us now, I think 5 weeks is enough time.
Fine.
And we can structure the directive separately, but
I would suggest that I create a separate hearing file to discuss the policy issue.
Okay.
Because it's not directly related to the request for documents.
Through the Vice Chair, I do have a suggestion on this, and that would be to re-find the violations that are currently against the MTA, to hold the place of those. The order of determination can carry over to compliance and amendments separately. Add to the order of determination a review, or that they send a representative who can provide testimony about their policy for handling Sunshine Ordinance requests and compliance with orders of determination from the Sunshine Ordinance Task Force.
And perhaps that could have a separate timetable for that second piece.
We can make that decision at the committee level.
Okay. All right. I like that.
I don't even know that it needs that much formality. I think all we need to do is send it back to compliance to discuss the things that were just talked about, and it doesn't need a new order, and, we've already found the violation.
That's fine. We haven't found compliance, so the order is still not been satisfied.
Outstanding. Okay. All right. Do we need a motion on that?
A motion to re-refer to Compliance and Amendments Committee. So moved, and we still need to take public comment.
Yeah.
The motion is to re-refer this matter to the Compliance and Amendments Committee, and we are going to add the request that they provide
knowledgeable
representative
representative
to discuss the policy as to how the department handles
future
requests for
future
sunshine requests and order of determination handling.
Very good. And do we have a second for that?
Second.
Okay. We're going to take some public comment on that. You people can all take a quick seat. Thank you.
I have public comment. Ha ha ha!
I'm sorry. None of that is public comment. It's not. Then speak. Okay. We'll turn the microphone on when you speak on this topic in a respectful manner. That was not respectful. Carry on.
I can't hear myself. Good, thank you. My public comment is, and the reason I'm laughing is because for 20 years, how long has the Sunshine Task Force been around? 20 years? And aren't all departments supposed to sign every year saying that they know exactly what Sunshine stands for and how it's supposed to be enforced and what they're supposed to do? So I think my comment was correct.
Is there any other public comment on this item? Seeing none, public comment is closed. Should I take it? Ms. Bondi, go ahead. Yeah.
My question is, if I get whatever I was supposed to get in time, and if it's not to my satisfaction, and I have evidence or proof, do I bring it to the Sunshine before the date, or what? I don't.
Yeah, so what we're going to do is without objection, we're going to give them one more chance on December 16th to present the information that they should have presented. Mm-hmm. And then I believe you'll get to review that information. Mm-hmm. We'll get to review that information. Mm-hmm. If it's not to both of our satisfactions.
Or complicated.
Yeah, we'll deal with that at that point. Yeah, that's the procedure.
And they're going to send something in by December 10th, the week before, so that it's available, and you're going to see that. And if you have anything in response to that, then you should send that back immediately or present that at the committee.
Because it has to make it into the package. Exactly.
And Mr. Ellison is making a mental note of December 10th as a date to send us information.
The deadline for submittal of documents for the packet will be provided in the notice of hearing.
Yep. Okay. So basically,
ma'am, what are you confused about? I'm sorry.
Let me answer this.
Oh,
I
I'm
got
sorry.
this.
Yeah.
So they're going to provide all the information that they're supposed to.
Okay.
You're going to get a copy of that a week before the December 16th meeting.
Okay.
The written copy.
Okay.
So you'll have a whole week to digest that material, and when you and they come back before Member Hepner's Compliance Amendments Committee, you can then say, okay, I still didn't get this, this, and this, and this. And that'll be an opportunity for them to say, well, actually, we did do this, or we don't actually have this. Okay. That'll be your chance to discuss what you got and whether it was everything you need. So you'll have a week to review what they've provided, and then at the meeting, discuss whether that satisfies your requirement.
Okay, I'll go home and dig in my papers.
All right. Thank you very much. Thank you. Mr. Clerk, can we take this without objection?
Yes.
Okay. So moved.
Next on the agenda are items number 10, 11, and 12. Item number 10, file number 14076, complaint filed by Jason Grant Garza against the Department of Public Health for allegedly violating Administrative Code Section 67.21, 67.25, 67.26, 67.34 for failure to respond to immediate disclosure requests in a timely and complete manner on April 30th, 2014. Item number 11, file number 14077, complaint filed by Jason Grant Garza against the Department of Public Health for allegedly violating the Administrative Code Section 67.21, 67.25, 67.26, and 67.34 for failure to respond to immediate disclosure requests in a timely and complete manner on July 23rd, 2014. Item number 12, file number 14078, complaint filed by Jason Grant Garza against the Department of Public Health for allegedly violating the Administrative Code Section 67.21, 67.25, 67.26, and 67.34 for failure to respond to immediate disclosure requests in a timely and complete manner dated on July 29th, 2014. Originally, these were one file with 3 complaints listed in there. I did separate them into 3 separate files. That's why there's that language there concerning 3 immediate disclosure requests. My apologies for that.
Repeat that last statement.
I have a statement in the item number 12 stating 3 immediate disclosure requests. That is a clerical error where these 3 items were consolidated into one. I did separate it out into 3 separate files to constitute 1 immediate disclosure request for each file.
Because they all occurred very close to each other.
Yes, it was. As far as I know, they are the same subject matter on 3 different dates.
Thank you.
Next time, one file. Better.
Through the chair, may I ask Mr. Garza a question?
Hold on.
Yeah,
We're
sure.
not quite there yet.
Yeah.
Do we need to determine jurisdiction?
I believe Mr. Kola has a comment.
Mr. Kola?
I think in the complaint description, it referenced that these were IDRs on 3 separate dates, but everything in the file that I found indicated that it was all the same date.
It's within minutes of each other. That's
Yes.
what I read. Yeah, okay. And is jurisdiction contested by either party? Seeing not, can we find jurisdiction?
Do we have a mover?
So moved.
We have a second.
Second.
Third.
Without objection?
Is there any public comment on jurisdiction? There's no public comment. The jurisdiction is found without objection.
Okay. Mr. Garza, please approach. Member David is going to ask you a quick question, then you'll have your...
So, Mr. Garza, I'm just curious. I feel like we've heard these issues from you in the past, and I just want to know: is the fundamental issue that you're bringing up before us today that you believe that your medical records are public records? Is that what we're fundamentally going to be discussing again?
I know that my medical records are public records. It's been decided by the Sunshine Task Force as such in the past.
So the answer is yes, that is what.
But that is not what we're going to be discussing today. What we're going to be discussing today is the fact that I went to the emergency room 3 different times, 3 different dates, and was denied emergency care. And then when I went to go seek the records for that, which are supposedly medical records, I was denied those under the IDRs. Why this was consolidated, I do not know. This was 3 separate incidents, 3 separate dates, over 3 separate months. So, truly, I don't see where my due process is being afforded here.
Okay, thank you very much. You now have up to 5 minutes to give us the background for these 3 cases.
I'm sorry, 5 minutes for each case or 5 minutes for all 3 cases?
All 3 cases.
And why is that if I asked for them to be, separate and they're separate and I never agreed to them being consolidated?
It's our discretion to take them as one case. So you have up to 5 minutes to give us your summary.
So 3 different incidents, I'm only going to have 5 minutes. Well, okay, I need the overhead projector turned on. Please, can you turn that off so I can get situated and started?
You can always add to it if it's going somewhere.
I don't agree, but we'll just do it. All right.
It was 5.
All right. On 4:30.
We'll start your clock now.
Thank you. On 4:30 and 7:23 and 7:29, I went.
Speak into the microphone.
On 4:30, 7:23, and 7:29, I went to San Francisco General Hospital seeking emergency services. In TALA, which is the anti-patient dumping statute, which is there for difficult patients and other things, requires that a medical screening examination must be provided when you're seeking emergency services. The burden of proof shifts to the hospital. That's what this is all about. I was never provided with a medical screening examination the 3 times that I went. That's what I requested through my IDRs. That has to be there by law. So, that's the Impala law. The reason I'm so knowledgeable in this subject is because in 2001, when my soulmate died, I went to San Francisco General seeking emergency services and was denied emergency services. And here is the settlement agreement by the Office of Inspector General in 2007 that was signed by both San Francisco General and the Office of Inspector General. We're in number 6. They admit that they did not provide an appropriate medical screening, which is required by law when you show up for emergency. And here is the signature of the guilty parties. 2007 by Gene O'Connell for San Francisco General and Kathleen Murphy, the counsel for the General Hospital. And on the next page, the signatures by the OIG. So once again, the Department of Public Health has violated and broken medical law because nobody enforces medical law, which is what I've been here before many times. They've always said that my medical records are not public records, which they are many times. Here is all the proof that, once again, I was denied emergency services. I even have the videos to show you if you would like to see them, but I think, the clock is ticking awfully fast, so if you do want to see those, I have the videos to show where I was denied emergency services. So I'm here not only, trying to gather the evidence I need to push this up to the Office of Inspector General, which will prove that I was not given a medical screening examination, which by law must be there, which is what is in my IDR. I'm requesting the medical screening examination or an admission that they broke federal law. So these are all the issues that I'm bringing forward, and I would like for them to be addressed by the Department of Public Health, which will probably tell you, because you people have never set the precedent that one's own medical records are, in the public domain. And this will probably just continue again, because the next thing I'm going to be requesting is the videos for these 3 incidents, which we've already known from the sheriff. They don't have the videos for the other things. Hopefully, the videos will be provided for these separate incidents when I sunshine them for them in addition. Also, I went to go pick up my medical records, and each time that I went, there were several times that I went to see, for example, Philip Katzenberger, who was the director there, who denied me my medical records under HIPAA. And when I took HIPAA law, because I have it,
down the volume, much as possible,
it could not be pointed out as to why. I was told that I would have to sign a HIPAA release form, which when I was sent the HIPAA release form, specifically states that you do not have to sign it. I understand this disclosure is voluntary, and I don't have to sign it. Oh, it's just amazing the different ploys that the city will use in trying to break the law, circumvent the law, and of course continue to harm me, the person who's dead right. Let me say that again, dead right. Let me say it for a third time, dead right. As proven by my settlement agreement from the Office of Inspector General, as proven by the fact that I've been here to Sunshine multiple times, and this is just going to continue to happen because you guys are powerless, and if you find them guilty and send them to ethics, nothing will come of it. So the outcome will be that nothing will change, and that I'll probably be here again when I request the videos for these 3 separate incidents in addition also. But this is why I'm videotaping this, so that the world can see how the Ministry of Sunshine does not work. Thank you.
Mr. Garza, can I ask you a
Thank
quick
you.
question, please?
Let's hold that question until the question answer series.
Oh, okay.
Okay.
Respondents, please approach.
Good evening. Nancy Sarai from the Department of Public Health.
Welcome.
Thank you. So I'm glad it's been clarified that the 3 requests that are consolidated into one were received all on the same day that were minutes apart, and they were referring to 3 different incident dates in 2014. So in our response, and I'm just regurgitating what I've submitted, on July 31st, since it was an immediate disclosure request, we responded to Mr. Garza, letting him know he was entitled to view his medical records and gave him directions as to how he could do that. On July 1st, again, we responded to the second request, letting him know that our office had no records responsive to his request for that date. And on July 31st, regarding the third request, we responded letting him know, once again, you're entitled to view your medical records, and gave him directions as to how he could obtain them. And yeah, in summary, we feel like we responded to all three of these requests and fulfilled his request.
Okay. Are there other members that would like to talk?
Good evening. I'm Philip Katzenberg, Director of Health Information Services at San Francisco General Hospital. I would like to actually just make a notation that I did have my interactions with Mr. Garza. As noted by Nancy, that we did actually we provided him access. We gave him the process. He chose not to actually sign for his records. We did provide him his records, as he noted, as a document that he presented to you. As you see, there was 2 witnesses that were notated there, so he has any and all of his medical records at this time.
Okay, thank you. And the third member, would you like anything to say? No.
Just present him. It's Dr. David Pine. He actually presented Mr. Garza with the records when Mr. Garza did meet with him. So.
Okay, great. Thank you very much. Go ahead.
As a medical record stands as being a public record versus a legal record, I'd be more than happy to explain that piece of it if the committee or the members would like.
Thank you. We'll probably get to that in a few minutes in our deliberations. Okay, this matter is before the task force.
Member David.
Member David?
Oh, yeah. So Mr. Garza, I had a quick question for you. So you started off by saying that you were denied medical services, and you were bringing that before the task force. And you said that you showed a page and said that you went to the emergency room and you were denied medical services.
I was denied emergency services on 3 different times, and I have the videos on YouTube.
So I'm just curious, that seems way outside of what the task force's ability to resolve
I'm not asking you to have them provide me with emergency services. Under emergency services, a medical screening examination must be performed, and that report is what I'm asking for under the IDR. That I have not received. When they said that they gave me everything, and this thing that I showed you, that thing that I showed you was based on prior records that I had asked for, not the 430, the 723, and the 729. They are mixing apples and oranges, and they're not telling you the truth. Also, Mr. Katzenberger said that I went to go over there to see him. He did not give me the records at that particular time. Those videos are on YouTube. You're being misled.
Okay, so let me, please. So you're asking for, I just want to be clear, the record that says that they denied you emergency medical services on these 3 dates. Is that what you're asking for?
No, sir. I just showed you Impala law. Impala law states that when I show up and declare that I am an emergency, they must provide a medical screening examination. I also showed you a signed settlement agreement where I had shown up in emergency in 2001 and had been denied that and requested a medical screening examination, and that was not provided for, and that's what the settlement agreement was signed for.
Mr. Garza, here's the question.
Yes, please.
What documents do you still feel you have not received?
I've not received a single medical screening examination document from 430, 723, and 729.
So there's 3 documents, and those are if you like, the intake medical screening documents. That's what you're referring to. Is that right?
The medical screening examination is different than triage. It's different than intake. They're totally different. Triage is not a medical screening examination. No.
Okay, medical screening examination document. Okay.
Correct.
If you can just take a seat, please. I actually had a question for either that or the doctor. Yeah, go ahead.
Dr. Phil, perhaps.
Yes.
I'm sorry. Give me your names one more time.
Philip Katzenberger.
Mr. Katzenberger, what is your standard procedure for receiving a patient in the circumstance that Mr. Garza described? And is that document that he's describing always generated?
So the answer to your question, the process is normally a patient would come in, and there's multiple ways they would come in through the ER. If they come in on their own, they would be registered. They would actually be triaged. If they had certain symptoms, they would be processed differently. Okay. With that priority, they would actually then get, like he indicated, triaged and then visited there at that point. our process of actually obtaining those documentations and so forth, if the patient's never registered, that is not something that we'd actually have a full medical record document on that.
Okay.
He would not be billed by that. He would not actually have any form of, view of it.
Okay. Member Pilpel?
So just to clarify on that, so a medical screening examination report, if that term actually makes sense here, that would not necessarily be created anytime someone shows up at the ER. It depends on what stage you get to in your process.
You are correct in your thought, yes.
Okay.
So it's your position that you don't have any documents, you don't have those documents responsive to his request because those documents were never created?
That's correct.
Okay. So
it's a question of that's standard hospital policy. Sometimes that document's created, sometimes it's not. Depends on how the person comes in. But is there some record of someone showing up? I guess that's what I'm getting to.
We do have a log, and we do have an ability to actually monitor who comes in and who leaves.
Okay.
And we have multiple levels of when people leave, when they're not seen, or when they're registered and they leave, whether they're triaged, evaluated, and they leave in those increments. So
Gotcha. Okay.
we comply with EMTALA law.
All right, and how they come in and how they're processed and how they're released is under your purview and your call as to their condition, et cetera, et cetera.
I would
people
say,
in general.
As San Francisco General, yes, but
Okay.
I am not. It's not my.
No, I meant you as a hospital.
Yes, yes.
Thank you. Member Pilpel?
So at the risk of trying this a slightly different way, to Mr. Garza, if the department has represented that all of the medical records about you that they have given to you, and whatever other records you've asked for don't exist, given that, what else is there?
You've obviously failed to understand EMTALA law. EMTALA law states that when I show up, the burden of proof shifts to them to prove that I'm not an emergency, and a medical screening examination must be done, not a triage.
Okay.
It
Hold
done.
Hold on one
Mr.
second.
Garza. But if they don't have that, and if we're not the medical review
Then they
panel,
broke federal law by not providing emergency services.
But we don't adjudicate federal law here. You should take that up with somebody else.
But
okay?
I'm trying to get my records to prove that they didn't do that.
But they don't have any of those
because
records.
They broke the law and did not provide what they were supposed to be providing with a medical screening examination.
That's a matter for another court,
right?
Not this one.
If they said that they've provided all that exists, that's all we can do here. And if there's no other record to discover, then maybe we're done with this.
So basically, if I walk in and say that I'm an emergency and they tell me to leave because their security guard wants me to leave and I don't get a medical screening, you're done with it because they, don't have to do it because, like you said, that's
Somebody
for me
else
to take to a
may
different
have
court.
jurisdiction over that.
Pardon me?
Someone else may have jurisdiction over that, but not us.
That's legal.
I'm sorry. I thought you had jurisdiction over my sunshine request, which was for my medical screening examination, which by law has to be there.
Yes,
and if they don't have it,
but
then
your issue, Mr. Garza, is whether they're legally required to provide those forms. That's nothing to do with us. You're in the wrong place.
No, my issue is that I'm supposed to try to get that form to prove that they either did or they didn't do it.
You can't get it
by
through
law.
us.
Of course I can't get it because they didn't provide it and broke the law.
Okay. And that's the case for a lawyer.
Like the case I had before, where I took them to federal court, where they testified, committed fraud, had my case thrown out, only to sign a confession years later admitting that they had broken federal law. So they're free to do it again. Next time I go to emergency,
thank you very much.
They're free to do it again.
Thank you, Mr. Garza. Please take a seat.
Is that your take? Then okay, I'll go again.
Members, any discussion on this? I think this is coming to a very narrow point in my mind. Anybody else want to add anything?
Nope.
Respondents, you have up to 3 minutes to summarize your position.
So just want to add that on August 11th, 2014, Kelly Kruger, the psych liaison from the police department, as well as Dr. David Pine from our department, met with Mr. Garza and provided him with a copy of his medical records. And on August 11th, later on that day, Mr. Garza emailed the Department of Public Health acknowledging his meeting with Kelly Kruger and David Pine, where he received his medical records.
Thank you. Mr. Garza, you have up to 3 minutes to summarize.
Well, that is not true, because I have the videos of where I received the medical records for something prior, not these specific ones that I've been asking for. That's on the YouTube video, so that is not true. You know, also, the next case that we're going to be hearing is about the fact that when I received...
We do the next case next, please. Stick with this case now.
Okay, so basically, like I'm saying, and no, I have not received my medical records because my medical record request was for my medical screening examination, which by law must be there, unless, of course, they broke the law, which you're telling me I have to go somewhere else. And when I go back to emergency, I guess they're free to break the law again because that's the way it's set to fail. Thank you. This will go on YouTube.
Thank you. Members, is there any motion here? Anybody? Is there any public comment? Seeing there's no members of the public in the room, public comment's closed. With no motion.
There being no motions, the matters are concluded. Item number 13, file number 14082, complaint filed by Jason Grant Garza against David Pine, Nancy Sarah, Barbara Garcia, Philip Katzenberger, Department of Public Health for allegedly violating Administrative Code Section 67.21, 67.26, and 67.26, Section 67.21, 67.25, and 67.26 for failure to respond to immediate disclosure requests in a timely and complete manner. Determination of jurisdiction.
So moved.
Without objection. Second. Too slow, Ali.
There being no public comment on jurisdiction, the motion to find jurisdiction passed without objection.
Okay. Mr. Garza?
Okay, this IDR was to specifically request the HIPAA release form for David Pine to have gotten my medical records because HIPAA means that I control my medical records and who is supposed to get them. When I requested my medical records for a prior incident and everything, Dr. Pine gave them to me on 8/11, and it was witnessed by Kelly Kruger, which is what I showed you here. You know, and it was filled out to SFGH, and it says that I don't have to sign, and he put that, and he noted that, but, you know, I nowhere in any shape or form signed a HIPAA release form for him to get my medical records to give to me. That's what my request was for in my IDR. How did he get these medical records to give to me? He's not my doctor. He's not my provider. He's not anything to do with it, and under HIPAA law, which I have to sign a release form for him to get those medical records. Or I can go in and get them myself, which I tried repeatedly and was denied. You know, when I went to San Francisco General, and I've got multiple videos of that on YouTube. So, you know, here is the other half of the equation. You know, I have not been giving the medical records that I sought under the IDR, which was a HIPAA release form made to Dr. David Pine so that he could get my medical records to give to me. This is a HIPAA violation.
Thank you. Respondents?
So this request was for the HIPAA release form or an admission that HIPAA law was violated and broken, and Dr. Pine is going to elucidate.
Dr. Pine will do his best. He has a bit of laryngitis.
Dr. Pine is going to opine. Sorry, I had to be the first to do that.
You were waiting all night for that.
I was. Okay.
I'm sorry. I'm a psychiatrist and a deputy medical director with Community Behavioral Health Services, which is the mental health, behavioral health division of the Department of Public Health. I became familiar with Mr. Garza by a different process, but it seemed to intersect with this dynamic. And when I became aware of some of his concerns about trying to obtain his medical records in person at San Francisco General Hospital, I spoke to the privacy officer and Community Behavioral Health Services and just, I guess, opined if there was something that maybe could be done, and if there's a way that I could help facilitate the process. That would have been Alice Gleghorn, from my understanding, had conversations with Mr. Katzenberger's shop, and it seemed like that they reached a determination that there would be a way, a HIPAA-compliant way, in which I could present to San Francisco General Hospital, take possession of any records that might have been copied per his requests. I never looked at those records, so I'm not even sure. It could have been blank pages in the envelope that I handed it to him. And I held those in my possession, kept them safe, and when I met with Mr. Garza in person on the 11th, I delivered those to him. I asked him if he were willing to sign the release that was provided to me by SFGH. He declined, so I made a notation of that, and Sergeant Kruger from the SFPD witnessed that.
Okay, thank you very much. Mr. Katzenberger?
Yeah, so to comply with HIPAA, and Dr. Pine's well within the realm of actually providing information to patients. It's his discretion. He has his oath of ethics to have that discretion. What we did is we did coordinate with Dr. Pine. We had him sign a release himself that we were releasing these records to him that he would give to to Mr. Garza. So in that mind, we have a clear track record, and that's what HIPAA complies with, which is, do we have a tracking mechanism on where and who do we provide information to? And then we clearly, we have that documented. And in lieu of all that, the jurisdiction of actually the medical records really is a legal document, and it is a business document that we have as the property of the hospital. The information itself is information of individuals. They're entitled for that information. We make efforts and we have process and policies that comply with Title 22, with CMS patient participation, with evidence codes. So we have a means and a mechanism to be able to provide that for the patients that do request it.
Thank you.
Thank you very much. Member Pilpel.
If we're done with the presentations, maybe is it Dr. Katzenberger?
Dr. Pine.
Yeah. Dr. Pine. One of you.
Or both.
Or both of you. Maybe this is a chance for at least me to learn a little bit more about HIPAA, maybe the rest of the gang too. A medical provider, is that the term that HIPAA uses, or one of the terms?
So HIPAA is really more about addressing entities, right? That entities are like a hospital, somebody that would be a biller, like a provider. Yes.
Okay, so within the construct of an entity, or a provider in this case, how do you consider public health? That it's one entity including the clinics, CBHS, General, Laguna Honda, or that they're separate operating entities all within the city? This is interesting.
Yeah, sure. Maybe I could define it a little better for you in the sense of how HIPAA's arranged is for medical necessity. I think that's where you're going with, is how is information shared. Under HIPAA, you can actually, it's a little acronym of PTO, right? So you have treatment, payment, or operations. If it's within those purviews, you can actually release that. You have to indicate, like you would have Dr. Pine, who would be on your registry, right? Or it would be part of our DPH. What would be his relationship what would his action of business to be with? That's the medical necessity.
So it's kind of a need-to-know basis, for lack of a better term?
That's correct, yes.
Okay. So within that sort of structure or umbrella, those people that have a need to relate to the patient record can have access to that record, and it's somehow noted in the file, but that doesn't violate any prohibition against disclosure to third parties because they're within the, I guess, the T of that TPO?
You're right.
Okay.
Right. So operations, right? That, as he indicated, he also took measures by not even actually looking at the record. He had no necessary business with that. He was actually being a conduit for it. Correct. So.
Okay. I've learned something. Thank you.
Sure.
Cool.
Okay. Member Remold?
I was just going to weigh in and say that I don't think HIPAA compliance is where we should be going. Unfortunately, Mr. Garza, I know that's what you want us to weigh in on, but that's just way outside of what we do.
Agreed.
Agreed.
Member Garza, if you'd like to. Member Garza, you've been here so often that I see you as a member. Mr. Garza, would you like to summarize?
Well, it's unfortunate that you've been led down a rabbit hole because, they keep saying that HIPAA isn't something I'm following over or that I'm not correct about HIPAA. They keep saying that they bent over backwards to give me these forms and everything else, the medical screening, and how wonderful they are. Well, my question is, why didn't they give them to me when I went down to San Francisco General, requesting them myself? Why did this whole rigmarole had to happen with David Pine and everybody else if they're not breaking HIPAA law and medical screening examination and EPALA and everything else? I went there many times to retrieve my records, and those videos are on YouTube where I was deliberately denied by Philip Katzenberger my medical records. So does this mean that every time I have to get my medical records, I'm going to have to go through Dr. Pine or Kelly Kruger or some other person because my HIPAA rights are being violated at San Francisco General because you guys, can't weigh in on that either? It's really confusing because I guess I'm going to be coming back asking for more because apparently, none of my rights are being withheld here. Because I'm entitled to my medical records. I didn't receive them. I asked for the medical screening under IDR, which must be there by law, but you guys are washing your hands of that in addition. So, I guess I'm going to have to continue to come back and continue to, be sick. And maybe one day I will die and you guys won't see me here anymore. And as you said, maybe I won't be a member of the Ministry of Sunshine. But, unfortunately, I'm dead right. So the next time I ask for my, shall we say, videos for these 3 separate instances, because I can't ask for them, and I get denied them because they're under medical records and everything else, will we be here again recreating this wheel? I believe we will be. But that's okay, because this is what I'm expecting from the Ministry of Sunshine to post on YouTube. This is what I'm proving, is that there is no medical law enforcement. And when a person needs to get records that should be there by law, you guys don't even stand behind them. You wash your hands. So you haven't disappointed me. Unfortunately, I'm warning you that I will be back. It's gone on for 10 years, and it will continue to go on for more years. And I've shown you and the YouTube audience of how exactly the laws are being broken and how no one is there to enforce my rights. And now you're saying that this person, Dr. Pine, was my provider. He's not my provider. Had he been my provider, then I could technically, right now sue him for abandonment because I went to him to go to a clinic, which he still hasn't set up for me. So all this is BS, and it's all on YouTube. The whole world is watching. Thank you for playing your complicit part.
Thank you. Respondents, if you'd like to summarize.
Yeah, so just to loop back around to the actual request for a release form, as you clearly saw because Mr. Garza presented it, we mailed out using certified mail on August 21st the release form, and it was received by Mr. Garza on August 22nd, and he emailed us saying that he was in receipt of the piece of mail that we sent him.
Thank you very much. Member Pilbel.
I'm sorry, I still wanted to learn a couple of things. So Dr. Pine, for example, or Mr. Katzenberger?
Keep it brief.
Okay. So
one question.
So if someone at who's received treatment at a hospital or at a clinic or somewhere within DPH's system wants a copy of their medical records, if it's at SF General, do they come to your office? Are you the guy for that?
So individual clinics are going to have their own records.
Okay.
Eventually, we will eventually get to that point, but at this point, licensing kind of defines the barriers.
Okay.
So if
if I'm seen at SF General for whatever reason, those records are kept at General, and you're the guy on that?
That's correct.
Okay. And if I'm seen at a clinic, there's someone at each clinic that's the records person, and Ms. Gleghorn or somebody in the central office is responsible for coordinating that?
So, yes, we have another subdivision of medical records in those areas.
Okay, so what I'm getting at, for each area within DPH, there is a medical records person, and somewhere that's clear that if you want your records, here's the person to go to. There's a process, there's a form, you either sign it or you don't, you document it. There's a way for each individual to get their individual medical records wherever they're treated within DPH.
That's correct.
Thank you.
Thank you. Members, is there a motion? Seeing none, this matter is concluded. And I'd like to add, Mr. Clerk, future sunshine requests, complaints that are out of a medical nature, if you can add an additional threshold to talk to the complainants as to what they're actually seeking, if it's HIPAA or Title 22 related, just to make sure they understand what our purview is, what we can provide, and what we cannot opine on. That will be helpful down the road. Member Pilpel.
I'm thinking actually in relation to medical records, just as I commented earlier about MTA, maybe this is something for the department or something for us to work on. We should probably have a standard one-pager that says, here's how medical records work, here's how employee records work, here's, I'm not volunteering to do that right now, but it's something to think about, that there are these things that just come up over and over, and there are sort of standard.
It'd be great to have that on our website. I agree.
Yeah.
Just to have a primer,
So maybe we can just make a note, kick that to OT at some point. Some of these standard things, we shouldn't have to keep trying to reinvent because there's nothing new there.
Right.
And we should probably use DPH's help to develop that.
Yeah. Okay.
In terms of radical.
Thank you. Thank you, Mr. Garza. Thank you very much, everybody, for coming in. Next item, please.
Would you like to go back to the Ethics Commission item? Or
Yes, let's go to item number 3. If Mr. Hepburn.
Item number 3, file number 14093, hearing Ethics Commission's policy discussion regarding Sunshine Ordinance Task Force referrals.
So, Mr. Maynardi came in and talked a little bit. We had some questions, but if you want to provide a quick overview, and we can kind of craft where we are as a body.
Right. Well, I just in terms of charting the path forward on this, I think it's having looked at this Ethics Commission on a few occasions, on this report a few occasions now. I think that some of their concerns can be answered with just an explanation of the procedure that we adhere to here, and those explanations, inform which of the options are most in line with what we do. For instance, the first issue in here addresses the Ethics Commission's concerns that oftentimes there are inconsistencies between the referral to them and what was heard before the task force. And I think what they're getting at is the fact that oftentimes, for instance, we'll find violations in addition to those that are set forth in the complaint, or different than those that are set forth in the complaint. So the Ethics Commission, I'm not sure, has the clearest understanding of how complaints come in, how potential sections are included in our memorandum as proposed violations that we could find, and then how our deliberations lead to violations that may be even outside of the memorandum that comes our way. So my inclination then is to say that our referral to the Ethics Commission is the binding document, and that they should not be so concerned with the complaint and memorandum that came to the task force originally. That certainly puts the onus on us to craft a very nice referral that explains the basis for, our findings. And to the extent that they would like it, an explanation for why the violations that we found were different than the violations that were proposed in the memorandum that came before us initially.
And that goes in line with what we're trying to do, writing better orders of termination and more detailed.
I think so. I think it's part of the same conversation, and I appreciate Mr. Maynardi's effort to sort of push us in that direction of refining our procedure as well. So, as to that first issue, I think, on page 121 of our packet, there are 4 options, and I think that we should decide which of those is most agreeable, and to the extent that none of them are, which we would like to refine and sort of present to the Ethics Commission as, well, this is how we function, this is how we operate, and this is how the Ethics Commission should interpret what it perceives as an inconsistency, when in fact it may not be. So
I'd actually like to just maybe even add another option. It's just that we don't consider it inconsistent. If it's outside the original complaint, they're listing that as inconsistent. Am I reading that correctly?
Right, and that's option 3 there, where it's adopt a policy that the Ethics Commission should consider the violations and respondents indicated in the referral letter without reference to the task force proceedings. That is to say that they're not going to look at inconsistencies between the proceedings and the referral letter. They're just going to go with the referral letter.
Mm-hmm.
On that?
Sure.
So, and Member Hepner, you might want to watch the first 2 hours or listen to the first 2 hours of our meeting tonight, because we talked about this a bit as it related to the sheriff and some of their procedural things. But without repeating that, I think that we should include, and I'm hoping that this is moving toward a letter that you're going to draft to send to ethics, summarizing our views on these things, that where we make a referral, and again, it's not specific as to the language or the scheme that I used in the draft Mayanki referral, but that we should provide a relatively detailed referral letter supported by findings, either always or where warranted, to explain the task force's position. That's my view. I think that it is a fairly common occurrence that we find violations of the ordinance. It's a relatively rare thing for us to send a matter to ethics, and I think it should be a relatively rare thing, because it should be those things that are so egregious as to warrant further enforcement action. But I think in those cases, we should have a somewhat higher burden of explaining the background, the situation, if necessary, who was named, what the dispute was factually and legally. And we've done that, I think, inconsistently over time. The extent to which we explain that at a greater degree, I think, is the extent to which there will be less perceived inconsistency. What they're calling inconsistency, I think, is more from lack of explanation than some real procedural defect.
I absolutely agree.
Okay.
Right, because what they perceive as an inconsistency is in fact just maybe a lack of explanation from how we got from point A to point B to point C to a referral to the Ethics Commission, and how that transforms, how the complaint transforms over time in process into a referral to the ethics complaint.
So perhaps something can be worked into the language that incorporates option 3 or some element of that, along with a more, again, the issue of a more detailed referral letter and possible findings.
Right.
Okay. So, members of the task force, this is your chance to kind of weigh in as we go along to these different positions and kind of get a consensus so that Member Hepner can build a response or a letter if you like. Yeah. So moving along, Member Hepner, what's the next?
Right. Issue number 2 is the task force's referral to the commission alleges that a department head violated the Sunshine Ordinance based on acts by his or her subordinates. This is obviously, this surfaced very recently, and again tonight.
Did, yep.
And the potential options for department head responsibility, again, I think are interesting and can lead to a discussion here. So option 1 is to adopt a policy of treating a complaint against a department, not a named employee, as complaint against its department head. In our conversations with Mr. Maynardi during compliance and amendments, we questioned whether department head should not also be, or in some cases be, considered the custodian of records for the department, who is likely to be more responsible for public records responses than a department head. Option 2, adopt a policy that the department head can be found to have committed a non-willful violation of the Sunshine Ordinance based on consideration of XYZ factors, which sort of mimic in some ways whether a supervising employer ratifies the actions of his subordinates through certain actions. Knowledge of or creation of the policy that lent to the result or the complaint in question. Whether department head had instituted sufficient Sunshine Ordinance compliance policies, right? And then option 3 is adopt a policy that the department head can be found to have committed a willful violation based on consideration of the department head's actual involvement in the records request or other matter. I don't see why in this case we couldn't effectively adopt all 3 options.
Right. I was going to say that.
Okay.
Or rather than adopt, convey to the Ethics Commission that all 3 options would be suitable.
Okay.
And then the third issue, how does a city officer or employee fulfill the obligation to send a, quote, authorized representative to a task force meeting? And
Can I come back to item 2
yes,
for a second?
yes, yes.
Sorry, before we
Sure.
leave that. I agree with they're not mutually exclusive, and they should adopt all 3. I think in general, and maybe if we can work this into our response, that we want to find, and we would like ethics to place the responsibility as close to whoever did the act or didn't perform the required act as possible. Where that's unclear or can't be determined, we will hold, and we would ask them to hold the department head responsible for the actions of the department, because ultimately that's where it rolls up. But it's not our intent, and we hope it's not their intent to just, nilly-willy find department heads. If someone else was actually responsible, that person should be held responsible. Does that make sense?
Yeah, but I think we're going. Ultimately, the buck stops with the department head, as stated in the ordinance. I think that's already in there. So for us to kind of get into that granular level, I think by adopting 1, 2, and 3, we adequately.
Right. I just don't
take
want
it on
to
a case
suggest
by
that
case.
either we're going to, try to nail the lowest level person we can find or the highest level person. That we actually want to place the responsibility where it is as best we can divine.
And I think that's.
If we can convey that somehow, that would be good.
I think that we should be very conscious of when we find a violation against a department, and we should have an internal understanding of what it means to find a violation against a department, whether that means it's against the department head or the custodian of records, and we should do our duty to investigate who the responsible party there is there. And I think that Member Pilpel's concerns are addressed adequately with option 2. And if we think that if we find that there's a defect with the sunshine policies in the department, and it's a policy issue, it's a procedural issue that is, sort of endemic to that entity, then that's where we can find violations against either the custodian of records who crafted the policy or the department head, if that's where we find where the buck stops.
Okay. All right. So, third issue.
And are we okay? We can just, with option 3, that it's only a willful violation against a department head if they were directly involved in the response? Or in this case, actual involvement, which may be different than direct involvement?
Well, the Ginsburg case comes to mind because he wasn't involved until the very end, yet we're finding that willful.
This sort of...
It seems to punish a department head for getting involved, and that...
Right.
Problematic.
It's a good point. On the other hand, is there no way to find a willful violation against a custodian of records when that custodian of records created a defective policy but was not involved in the actual response to the records request? I imagine that's a pretty rare occurrence, but maybe the Ginsburg case is one that issue has come up.
Mm-hmm.
If there are no thoughts on that, we can move on. But
okay.
The third issue: how does a city officer or employee fulfill the obligation to send an authorized representative to a task force meeting? And I remember wanting to go above and beyond what what these options were. Option 1 was adopt a policy that requires an authorized representative who is actually involved in the records request to attend the hearing. Option 2, adopt a policy that requires any authorized representative, so long as that person is briefed on the matter by that officer or employee. Or option 3, adopt a policy that requires an authorized representative to mean so long as that person is able to accurately state the response of that officer or employee to the task force. And this is a tricky one. In the MTA case, for instance, with Ms. Hairston-Omandi and with many cases, what we essentially try and do here is get to the bottom of what efforts were made to respond to the request. And if they're not sending a person who has fairly in-depth knowledge of the steps that were taken to respond to the request, and in some cases, knowledge of what documents exist, then it's a tough call. I think that...
I'd like to see language in there to the effect that if they fail to send someone that's knowledgeable and especially can answer questions in front of this committee, that the next time that person, they send someone, the department head accompany them, because ultimately it's going to roll up to them to answer these questions. And it kind of underlines the fact that if you don't have someone in the department they can stand up here and talk to us about your sunshine policy, you have a problem. And it's ultimately going to hit your desk and your neck. I mean, I don't know if that's too strong language at this early stage, but I mean, if we've already hammered home point 2, point 3 kind of follows in my mind.
Right. I mean, it's not just what the response was, it's what efforts were made to respond.
Yeah, like option 2, I don't like that language. So long as the person is briefed on the matter, that's not enough. They need to be briefed, they need to be able to answer questions, they need to be thoroughly conversant with what they're going to present to us. That's just too weak, and that wastes our time, wastes the complainant's time, etc.
Right.
Can I...
Go ahead.
I'm leaning towards option 3.
Actually, just one quick timeout. DCA Cola, if you'd like to listen in for the rest of this, you may. I don't know if we would. It seems like we're moving along this pretty quickly. I don't think we're going to need your input on this. I would love to give you some time off if you want.
There's a budget for me till 9. I could stick around till 9 if need be in case anything comes up.
What if we had 45 minutes to another session?
I do have a question for you, DCA Cola, though.
Use them or lose them?
On the issue of naming department heads in a violation, in order of determination, when that department head was not named in the complaint, I'm persuaded by this Paul v. Davis case that may not really raise due process concerns.
Yeah, I remember Pilpel had voiced this earlier, and I'll have to read through the case, and I'll have to talk to my supervisors and see how they think we should rule on this issue. But I think ultimately, I mean, if we end up doing a referral to ethics in any instance, and someone alleges that they weren't afforded due process, they're going to come back and say, well, now I'm not merely facing a damage to reputation. There's more there.
When it gets to ethics, right?
Once it gets there.
But ethics is their opportunity for due process prior to a finding of willful violation or official misconduct, which could actually affect,
They have to retry everything, don't they? Don't they rehear the whole case?
Sort of, yeah. I mean, yes. There's a sort of
Chapter 3.
Mm-hmm.
Yeah.
Chapter 2, Chapter 3 distinction where essentially the burden shifts.
Historically, haven't they kicked things back to us because they felt like the department head wasn't named initially in the complaint?
That's only happened the one time. Otherwise, they've generally not found a violation, or in a few instances found a violation either as we suggested or something lesser.
It'd be really helpful to get to the bottom of that because, in my mind, it saves our time and allows us to be more accurate and effective if we can name a department head when appropriate, or a custodian of records when appropriate, even if that individual is not named in the complaint. But with the idea that they will be afforded their due process. And in fact, a violation of the Sunshine Ordinance does not rise to the level, I don't believe, of an affront to somebody's person, right, or property or liberty interests. So, but a violation by the Ethics Commission very well may. Yeah. But the Ethics Commission hearing is their opportunity at being afforded due process. So if some analysis there would be
sure, and I could put something together and have a more definite, more concrete answer for you next month's meeting.
That would be great. Can I weigh in on this?
Sure.
So where I'm leaning on this, I may have said this earlier, I think that our general hearings on complaints are not actually a due process hearing, that it's just finding a violation or not, whatever. When it comes to a referral, particularly if it's a Chapter 2 referral where the presumption is with the task force, I tend to think that those matters, and there aren't that many of them, that those rise to another level and may well be due process hearings. And so I'm more concerned with the notice and charges and how we write the agenda items on those matters than on a complaint. And that all gets wrapped up into this question of findings and how much detail, I'm putting a lot of emphasis on that referral because there aren't that many of them, and I think that we should have kind of a higher standard there.
And I think, though, even within the Chapter 2 hearings that we're talking about, there's another distinction between non-willful Chapter 2 hearings and willful Chapter 2 hearings. Willful violations by the Ethics Commission can result in a finding of official misconduct and potential suspension.
Yeah, it's serious stuff.
That's very serious, right? Right, but it does a non-willful Chapter 2 hearing rise to that level? Well, arguably not, because even with an Ethics Commission violation, you get an order to repair the policy or the defect that caused the violation, but there's no further result.
I mean, it can result in a note to an employee file, which the department head could then use as a basis for further action.
And I think that's sort of what the Paul v. Davis case is getting at, that the stigmatization created by whatever action is being taken. And when does that rise to the level of due process, a due process violation? Stigma plus.
Reputation plus. Yeah. I also think in terms of our procedures, kind of aside from this, when we get a complaint that names somebody at some department, I'm not sure that we should add the department head to that complaint, but I do think that we should copy the department head so that they are notified, and if they choose not to deal with it and buck it down to somebody lower, so be it. But they shouldn't ever be able to say, "Oh, I was never notified. I'm the department head. I've been here." Blah,
That's
blah,
in the
blah.
Ginsburg case, yeah. I agree.
And from the beginning, and whenever we issue an order, the orders should always get copied to department heads. And frankly, if we can find those people in the middle that are not the custodian of records and not the department head, but the person in between, they should be in the loop on some of these as well.
Agreed.
Because I think the more we cast the net, they will all want to avoid that net, it is
Agreed.
hoped.
So,
Anyway.
in the interest of moving along, Member Hepner, what's our summary on the last point?
Well, unless anybody feels differently, I think that it should be that an authorized representative is somebody who is capable of responding to questions about what procedure or what steps were taken to respond to the.
Someone that's thoroughly conversant on what happened and the policies in place, and can talk to the task force and answer for that custodian of records.
Right, and I think that incentivizes a bit more
care,
and a diffusion of responsibility across departments, so that people are watching out for each other's responses on these things. Perhaps it's not, the weight isn't always going to be falling with one person, but perhaps there's going to be, it incentivizes some checks in the process of responding to sunshine requests.
Mm-hmm.
I also had a problem with option 1 in that it requires someone actually involved, and we've heard a number of complaints against city employees or officers who are no longer serving in that capacity, and I don't want to preclude the option. We wouldn't have been able to hear the Gabriel Littrell thing. Just because someone is no longer in that capacity, they should be required to send someone who knows what went down and how, and all the things that Member Hepner just talked about. So I think expanding on option 3 actually makes sense.
I agree. And I'm going to sort of transcribe these into, a presentation that Allison or yourself or
I'll be out of town, so it'll be Allison. So.
Okay, and I will be there as well at the Ethics Commission meeting at the end of this month. But
I'm going to go as well.
Okay, to present sort of our thoughts on these. So if anybody has any additional thoughts, now is the time if you want to make it into my transcription.
Yeah, forward to Mr. Young. Forward it. Okay.
Thank you, Member Hepner.
Thank you, Member Hepner, for tireless.
Should we take a motion to authorize? Because I think this is actually conveying the views of the task force, and it's kind of that level of thing. I would so make a motion to authorize Member Hepner to memorialize our thoughts by way of a memo for Chair Washburn to sign.
Second.
Can we take that without objection?
Let's be sure that Victor's got it right. You got it? Okay.
Can we take that without objection?
Yes.
All right. So moved.
Next on the agenda is item number 14. Proposed amendments to the Sunshine Ordinance Task Force bylaws and/or complaint procedures. Actually, today I currently only have 2 items for you to review. One of them is the complaint form that we are currently using. I have been working with our records manager regarding this form, and we have made a few adjustments to it that we'd like to propose. We're adding a statement to the form that the staff will not be redacting any documents submitted to the Sunshine Ordinance Task Force. And we are requiring that the complainant provide at least one form of contact. Then that contact information will not be redacted. We are requesting that the box requesting confidentiality of personal information be removed from the complaint form. We also would like to remove the box requesting anonymous filing. And we would also like to suggest removing the option of the yes or no as to the request for a public hearing. We currently do not have a process to handle a complaint without a public hearing. And we do have 2 items where that request was made, and that's going to be in my administrator's report. And we don't have a process for that at this time. And that's something that we should be rethinking. Or if there's any other suggestions concerning the complaint form, please let me know. Otherwise, I would like to move forward with these changes if possible.
I have one question. That all sounds great. I just want to know that in the actual wording of the Sunshine Ordinance, does it specifically say that people are allowed to file complaints anonymously?
I believe it's silent on that subject matter.
It doesn't say that.
Okay, fine. That was my only.
All right. So, as proposed, do we need a?
I will be presenting this to my to the clerk of the board for final review, and if there are any additional changes, I will be bringing it back. But the motion is to amend the complaint form as provided.
Okay.
Is there a motion?
Yes, there's a motion.
Is there a second?
Second.
I'll second, but I believe Member Pimpel has a question or a point.
I'm with making the changes. I just wanted to sort of work through this for a quick second on page 645. So this is a version of the current form. The line, are you requesting a public hearing? That would go.
I did suggest that we would remove that.
Okay. And you still want to keep the contact stuff at the bottom? I mean, I don't care where, but that's the only thing that would change from this. Is that correct?
I removed several checkboxes concerning anonymity and confidentiality of personal information. And we did change the disclosure information stating that anything submitted is
public record.
Is a public record and will not be redacted.
Okay.
It's consistent.
Because we do have a problem with people submitting emails of several dozen emails, as you can see, with their email addresses on it, and I have to go through each one and redact each email.
I understand. I don't want to suggest in this note that either we're doing something we shouldn't be doing, or that we're not doing something that we should be doing. I think that there may be circumstances where we've got an obligation to ensure that things get redacted, irrespective of what someone submits. And, I noted in tonight's packet, we still, although there was lots of redaction, I still saw 2 addresses for Ms. Hairston Omandi. So stuff does get through, and,
well, that's what he's saying, that, SOTF administrator will not redact any information provided in these submissions.
We are still required to redact certain information, personal information.
Right.
Social security numbers and so forth.
Right. If I list your home address on the thing, got it. That we still have a third-party obligation there. So you'll check that text that it works. We're not going to censor their stuff any more than we have to, but we may still have obligations. Was my point?
Yes.
Okay. So if that's really the only major change from page 645, which is an update to the previous, I think the existing is.
Can we take that without objection, or do we need a?
We can take
Okay.
it without objection.
All right.
If there is no objection. There are several changes I needed to make to the complaint procedure in order to implement the complaints committee. I will go through the ones that I have made. They are underlined and crossed out in the version you have. I remove reference to documents concerning a procedure checklist that does not exist. That would be on page 1, line 28, and page 2, line 30. Packet of information regarding the complaint process. I do not have anything that refers to. And also the condensed checklist of procedures requirements, page 1, line 42. I do not have a condensed checklist. Page 1, line 42. That's page 648.
Quick question?
Yes.
On line 48, what's that C addendum? Is there actually an addendum thing? If so, fine. If not, that could perhaps be struck.
I will double check the addendum.
Okay. And maybe in the future, if there is an addendum, we should incorporate it into the base document. Otherwise,
And
so
the next item is the removal references to pre-hearing. That's on page 1, line 34 to line 37. The next item is to revise the criteria for excluding documents from packet. Page 3, line 21. I believe I wanted to reduce it down to 25 pages. There's a lot of contracts and items like that which I do not want to include in the packet. Next change I am proposing is change the continuous request from 3 days to 5 days. That one is not of major importance. That's at your discretion.
sorry.
We request that, yes.
I just wanted to walk through this. On page 2 at the top, the hearing schedule, this now, I guess there is no B, so maybe it doesn't need an A and a B. The chair assigns all complaints to the complaint committee? Oh, I see, or the full task.
Hold on. David, I think at this point, if you want to go through this in detail and
Well, I hadn't seen this
communicate,
before.
that's my point, and communicate to Mr. Young, I think that'd be a better use of our time at this point.
Well, we need to adopt this tonight, so now's the only time to do this.
No, I believe you're going to give one final version of this. Is that correct?
I thought we were adopting this tonight so that we can use this for Monday. Did I miss something?
It would be preferable, but I believe we can still proceed with the complaint committee.
Okay. Well, let's carry on then.
This is a side point, revised requirement for reconsideration of task force findings. I believe additional work we needed regarding that issue. Create a criteria for reconsideration that can be acted upon by the administrator. And I have a question of who judges what is new information. Next on my list is allow the administrator with the assistance of the city attorney to make initial determination of jurisdiction. This is regarding things like housing authority, where I do not want to bring it to the task force for determination that we know there is no jurisdiction.
Where is that buried in here?
I believe that's page 5, line 10 through 14. That is page 652.
Oh, there's the addendum. That's the thing. It says addendum.
Okay.
And then page 5, line 24 through 28, I wanted to provide a list of the function of the complaint committee. And my last item regarding this is to create a proposed summary of the SOTF complaint procedure.
Very good.
Oh, I see.
Okay. Thank you, Victor.
I guess I'm good with this for the moment, understanding that we will probably make further changes.
Exactly. This is
I
just
think
to get us off the blocks on Monday. So
I think on page 1, Victor, the line 10, where it's got the revision date, maybe if we can just change that to last revised. Just say, last revised.
Yes.
11/5/2014.
Yes.
And I assume the Rules Committee and the full task force will be looking at this in the future. I think based on our discussion earlier tonight, that whole section E on reconsideration, that's going to need to get buffed up. Some of the other things you just talked about. But with the changes that you're proposing with the discussion that we just had, I would so move that we amend the complaint procedures accordingly.
Second. Can we take that without objection?
Next on the agenda.
Yes. Hello. Are you here for a particular case or item? Oh, very good. All right.
Next on the agenda is my administrator's report. I'd like to skip through and go directly to item number...
Recreation open space.
Item number 3, policy review, processing of complaints. This is regarding the no public hearing option. I have 2 complaints where the complainant checked a no public hearing he does want the task force to make a ruling on his complaint. I have placed his 2 items on the complaints committee agenda for November the 10th. I have invited the department to attend. Mr. Mooney does have ADA issues and cannot attend, and my proposal is to have a hearing without his presence to fulfill his request for him not to have a public hearing, but we will still have a public hearing regarding his matter.
Okay.
I don't know if there's any thought on a different policy regarding this, but we are currently removing that from our complaint form, so it shouldn't be an issue in the future.
And we're just going to try this for Monday, and the assessor and the port are
Yes.
asked to attend, and we'll see all. So we'll deal with it on Monday.
This is basically a difficult
case.
A few issues.
All right.
Next, I have provided a summary. Please let me know if this is helpful or not. I have provided a summary of each of the new complaints that have been submitted in the last month. The 2 Mooney cases are the ones where we're going to hear without his presence. The first one is regarding the assessor provided his requested document in a different format than he requested. I believe that is allowed by state law. The second item, 14092, he's regarding index of records. The assessor recorder office does not have an index of records at this time. They're currently working on it. The port does have it, but it was not on the administrator's website. They have corrected that issue. 14094, Arts Commission, that is before the Compliance and Amendments Committee. We're currently reviewing the Arts Commission's process to try to resolve some issues that they have. 14095, Mr. Plantold versus members of the Land Use Committee. This is regarding taking additional public comment after proposed amendments. They believe that additional public comment should be taken. That is next on the list is 14097. This is fire department regarding public documents. I'll be referring that to the complaint committee. Next one is 14098, Charles Grissom versus Public Works. I believe this is regarding.
That's a follow-up?
Yeah, I don't think we need to summarize all of it, Victor.
Okay.
We'll get to them when we get to them.
The rest of the summary is written. I have listed which ones I am sending to the complaints committee.
Okay.
But this is helpful, I think, to have this quick little summary.
Yeah.
And on item 6, on the status of complaints, so there are 20 pending that are 2014. That's the most recent stuff?
2014, there are 20 pending. There are no more pending for 2013. Besides, of course, everything excludes anonymous. There are 20 2014 files remaining, and by my estimated, excluding the ones that I am sending to the complaints committee, we should be have those finished by the first meeting in January. Everything will be scheduled and heard.
Okay, so that then leads to my next question, which I think we touched on in passing earlier. If we're up to date, I thought that we were changing the committee structure to meet only every other month so as to get caught up. So once we get to that point, can we have the committees meet monthly as they did?
We have spoken with the clerk of the board. I am not allocated that kind of time for meetings. We are allocated for approximately 1.5 committee meetings a month. We have kind of pushed it slightly, and our solution was to have a meeting every other month for committees in order to keep the workload down.
Yeah. Okay.
Well, I thought we talked about this before. The trade-off then is that things sit and we're only meeting every other month at the committee and we're going to get kind of jammed I mean, Monday's going to be a long meeting, for example. And
Well-
then compliance is only meeting every other month. And so we may need to, particularly if we get caught up and our full task force meetings are shorter, we should try to push back and have a full task force and each of the committees meet once a month.
Yeah, we can eventually get back to that. I think we're going to give complaints a chance, on the back end of these for at least a couple of months.
All right.
Yeah, but duly noted. Yep.
So maybe we can revisit this in a couple of months, January or February.
Sounds good.
See where we're at.
Okay.
All right.
That completes my report.
Okay.
Item number 16, announcements.
Should ask if there's public comment, because we have public.
Yeah, I will do. Yeah. Would members of the public like to make any public comment to the task force since you're here? No, you're good. Okay. Thank you.
Next on the agenda, announcements, comments, questions, and future agenda items.
Members? Member Hepner? No?
Just the date of that Ethics Commission hearing? I believe it's November
24th.
24th?
Monday, I believe. Yeah.
Yeah.
It's a Monday. Is it?
Thanksgiving, isn't it?
Yeah.
It's the Monday before
It's the
Thanksgiving.
week
Yeah.
of Thanksgiving, it looks like.
So is it
yeah.
24? Is it what time is it? 5 p.m. Their meetings?
5:30.
5:30.
And I also would like to note that the Education Outreach and Training Committee and the Complaints Committee will be meeting this coming Monday.
Yeah. Have we sent the agenda out for that?
The agendas will be sent out by Friday morning.
Okay, we might need to talk about how long that is again. I want to revisit, make sure you send me the draft again. I think we talked about it last time, but let's take another look at
Yes.
that. Okay, thank you.
I'm assuming that's going to be more than 2 hours, right?
Yeah, it's going to be 2 hours EOTC and then straight into complaints, which will be probably another 2 hours.
job.
So we need to.
Motion for adjournment?
And also, I'm sorry, I had asked at the last meeting if we could get an introduction to our new members, since only one is here tonight. Maybe we can do that at a future meeting. I'd really like to hear about our new members and
Yes.
their background, and
Fair enough.
very much looking forward to that.
Fair enough. Oh, one quick question, Fiona. Pronounce for us your last name.
Hinsey, yeah.
Hinsey. Okay. So Victor has not been butchering it. I thought he might be, but
It's okay, everybody does.
all right. No, he's got it right so far. Okay, meeting adjourned. Thank you, everybody.